Eviction.
Eviction. Eviction is not this court.
My lord, my lord, this property suicide, running its business on a rental house over the common land. My lord. In this regard, my seeking right.
Bench 5, I am so. Any government land you go there.
May it please, Lordship. Item number 15, Lordship. We have earlier paid for some amendment, but the amendment will make it complicated. So we want to withdraw this petition with liberty to file a fresh petition.
Mr. S.K. Goswami, the learned counsel appearing on behalf of the petitioner submits that in view of certain developments, the petitioner would like to withdraw the instant writ petition with the liberty to file again. Taking into account the above, the instant writ petition stands closed on withdrawal. Liberty, however, is given to the petitioner to file afresh.
Obliged, Lordship.
May it please, Lordship. Item number 11 of today's hearing. The matter has become infructuous in view of electricity connection being provided to the.
Mr. D. Chakravarti appears on behalf of the petitioner and Mr. K.P. Pathak appears on behalf of the respondent numbers of the respondent APDCL. Mr. D. Chakravarti submits that in view of the electricity connection being provided to the petitioner, the further cause of action does not survive. He therefore submits that the petitioner may be permitted to withdraw the instant writ petition. Accordingly, the instant writ petition therefore stands closed on withdrawal.
May it please, your Lordship.
My lord, item number 46 of today's list, item 46,
Yes,
payment has been made. My lord, I think my learned friend has the instruction.
Mr. D. Chakraborty, the learned counsel appearing on behalf of the petitioner, submits that the order dated
My lord, order dated 6/12/2024.
6/12/2024, passed in WPC number
3908 of 2024.
and so, have been duly complied with. Taking into account the above, the instant contempt proceeding stands dropped. Mr. S. Doctor appears on behalf of the Revenue Department as well as Ms. Udas appears on behalf of the District Administration. This is a matter which has not been done.
Yes,
Means
that's not the only one.
notice was not issued.
Yes, yes.
So
That-
taking into account the above, the contempt proceedings stands closed, not dropped. Yes.
That can be kept on record, I suppose. That.
You say it has been, you
Mal-
got the
mal-
money. Matter over.
Obliged.
May it please, your Lordship.
My lord, item number 65, the lordship has fixed the matter for consideration of my interim prayer today. This is the carriage tender released by the IOCL, where the stand-up India scheme was under consideration by your lord, the activation of the scheme.
Why the matter has come up for orders?
Because your lordship, the National Credit Trust, I believe that the National Credit Trust organization, which is the umbrella organization handling those, there the postal receipt has not yet come back for them. Otherwise, all other parties have entered appearance.
Okay, we'll take it up after admission.
Yes, your lordship, with respect to item number 65 as well, your lordship, I pray for calling of the affidavit in oppositions that have been filed. Much obliged, your lordship.
Now, you know, I have to mention Article 52.
52.
Yes, for withdrawal, man. So petitioner, and we'll have to withdraw liberty because there is some.
What liberty business?
There is some defect, man. So there is some defect. In the
What
petition.
defect?
That is regarding my pending bill. Some bill are left to be included. So liberty will be granted to define. But
No. This is for payment of certain amounts.
amount,
So certain amounts, have you got the money?
no, my lord. But they
Then
said-
why you withdraw?
They said that they will consider, my lord, they will take.
If they have considered that nothing is there. Withdraw, simple.
Lord,
Mr. S. Nath, the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant writ petition. BTC, anybody? So and so appears on behalf of the BTC. Taking into account the above, the writ petition stands closed on withdrawal.
May it please, your Lordship.
Well, I beg to mention for listing of a review petition, my lord. It was filed on 27th of October, my lord.
Why? What happened?
My lord, review petition, my lord. Your lordship has passed an order, my lord. Subsequently, I have clarified some.
Huh?
I have clarified some certain facts, my lord, on that order, my lord. So, my lord, your lordship may kindly take into consideration. On to
Okay,
Wednesday,
when?
Wednesday, my lord. Wednesday, my lord. Next Wednesday. Oblige me.
May it please your lordship. May I beg to mention item number 22 of the daily list?
Yeah, what is this?
Lordship, the learned English counsel, Mr. R. Sharma, has said matter, your lordship is out of station. And with it, we have taken the concern of the other side. If the lordship allows, the matter may be adjourned for today and be taken up to a week.
What is the matter about?
Lordship, as per the records I've gone through right now, your lordship, the matter pertains to minor minerals and non-payment of royalties.
Counsel appearing on behalf of the petitioner seeks for accommodation, list the matter of the 3 weeks.
May I please, your lordship? Lordship, I am praying for listing of a motion matter for next day, lordship. In this regard, lordship, petitioner's bid was rejected, lordship.
Huh?
Technical bid was rejected, lordship.
When?
Lordship, on 7/11, lordship.
When do you want?
Witness, tomorrow, yeah.
Day after?
Like this, I take to mention item 20.
12? Yes.
That has become impossible.
Huh?
That has become impossible.
What is your name?
Okay, Malakal.
Ms. K. Malaka appearing on behalf of the petitioner admits that the writ petition has become infructuous. SMB? Anybody?
Mr. S. Dr. Myler, Senior Counsel, Mr. S. Dr. name may be recorded.
None appears, anyways. Taking into account the above, the writ petition therefore stands closed on withdrawal as it has become infructuous.
May I please, your lordship, this is a mention for
As Dr.
listing.
appears for the year.
Madam, in this matter, madam, what happened, as per last order, madam, this matter has to be listed after 1 week, madam. Only admission Kulamba, but not listed matter.
No
Ma-
date fixed.
No, madam, after 1 week was fixed.
Did I fix?
Yes, madam, on Wednesday or Thursday,
If
madam.
I have fixed without a date, means something is seriously wrong with your
No,
case.
my lord, it was fixed in other court. madam.
Ah, so I didn't do that. Why? What is it
Let it
wrong?
be listed, my Wednesday or Thursday.
Matter
madam.
pertains to what?
Pertains to, my lord, Jimma of Kettles, my lord.
Jimma of cattle.
Cattle.
Okay. Wednesday.
My lord, I'm obliged.
In item number 26, an affidavit in reply may be called for Malaysia.
May I please, your lordship? Your lordship, I beg to call for a listing of an IA lordship with regard to item 49 of today's daily list. We have
What is
filed,
that?
lordship, it's a contempt proceeding, lordship. We have filed an impleadment as respondent number 1 and 2 have left their post. Therefore, we want to implead respondent number 7 and 8. We have filed this IA on Friday, lordship. So if it's convenient, lordship may take it up today along with item number 49
No, no, no.
or
It
lordship.
has been submitted by the learned counsel appearing on behalf of the petitioner that that an interlocutory application has been filed. List the matter along with the interlocutory application.
Lordship, the matter is fixed for today.
Where?
49, item 49.
I've seen it.
Lordship,
So that is the order which has been passed in 49.
lordship, date may be fixed.
I can't fix a date. I don't know how many defects are there.
That's lordship.
May I beg to mention item number 28, may kindly be adjourned for the week
Why?
due to health issue of my senior. My senior could not attend today due to health issue.
You appear? No, you appear. Don't worry. I'll help you out. Next. You appear. If you have difficulty, I will adjourn it. Otherwise, no. We'll see.
This the lordship, I beg to mention for listing of a fresh motion matter in the as a protection item, lordship. The lordship, the matter.
Matter pertains to?
Settlement of tender, lordship. Lordship,
Okay.
there was.
Wednesday?
Lordship, can it be to the lordship?
Today?
Yes.
Oh, fantastic. Okay.
Hello, lordship.
Today.
The lordship, I beg to mention for listing of matter, lordship. Matter was last listed on 9/9/24, but till date it has not been listed.
Matter pertains to?
Payment structure.
Okay. We'll have it on 8th of December.
For 25, item number 25, we have filed affidavit in reply today, my lord. I have taken consent, my lord, can it be taken some other day, my lord?
No, you want to call for that?
It is in the process of filing.
Oh, if it doesn't come, then we'll pass an order. It has not been filed, we'll then proceed.
Yes, yes. Not urgent matter for district tomorrow, not correctly proceed.
Tomorrow, no. Today or Wednesday? Not tomorrow. Tomorrow is other people's day, no? You have to think about the hearing list also. Hearing matters are there. Today or day after?
Then let it be today.
Today.
At 2 minutes.
Affidavit, I may be allowed to bring it, my lord,
Ah.
25 time, my lord.
What is this?
Regarding the payment of bonus to the employee.
Huh? What are you challenging?
You find the.
Impugn minutes, issue notice shall not be issued directing AR so and so to so cause while the impugned minutes of AR should not be set aside.
Page 19,
Where is the minutes?
page 19,
Huh?
page 19.
Page 19. Yeah. Minutes of the tripartite held at the office of the Assistant Commissioner between Assistant Labor Commissioner, management of Pallarbon and workers representative of India regarding payment of bonus. Okay. Now this is being done, you are T-State.
Sir.
Why do you want this sitting aside?
So basically, we have offered to pay minimum wages, minimum bonus of 8.33%. Accordingly, we have submitted an application approaching this assistant labor commissioner that we are going to pay the minimum bonus since the company is in loss making company, and we are going to pay 8.33%. Therefore, on 16th of September, the meeting was called for. It was amongst the employees representatives, this petitioner and the labor organization. So on that day, meeting was could not held also due to some difficulties. Then it was held on 18. On 18 also, the same offer was offered by this petitioner that we are going to pay on the 8.50%. Since the company is a C company and loss making company. However, this assistant labor commissioner and some I do not know some person might be behind the scene. Who gathered some labors and raised the situation under scholarship, and accordingly, the petitioner was compelled to sign this agreement.
Then?
So, we are only in a position to pay 8.33%.
No. Whether you have agreed, you have duly agreed out there, you have put the signature.
That is all.
Now all these things happen. Now you see, Mr. Kulta, first of all, you people appeared. On 16/9 it was fixed. Then comes, you say that you need time. On 18/9, you say that under caution you had to sign out there. That is what. Now you go for a lockout.
Lockout, yes, lockout is.
Yes. Now the question as to whether the lockout is legal or illegal, that is going on.
That is different issue.
That is different aspect. Now, as to whether this is to be set aside or not, now raise this as an industrial dispute. Why should this court interfere as regards your tripartite meeting? You are making allegation against that official concerned that he has forced you. So take it up. What is this court going to do out there?
But immediately after signing this agreement lawsuit, we have submitted an application before the deputy commissioner also, that is on case 24. That's on that day lawsuit, he was compelled to put his signature, and under such circumstances, he has lawsuit no option but to lawsuit put his signature. So that representation has also not been addressed till the first.
Whether you have gone for a lockout rightly or wrongly, that is another aspect which, no. Both are entering, you want, therefore, once you get the set aside of this, the tripartite meeting set aside, then your lockout becomes legal. Mr. Kolta, I also understand what is your intention behind it. Your intention is once I issue notice in this matter in respect to the tripartite, then you tell to the officials concerned that look here, we have replied, kindly don't take any action against this.
In this petitioner also, because although some PF dispute is also there.
Yes, you are appearing for whom?
It's not the PF part. It is not the case of PF. This petition was filed. It was listed subsequently because of lawsuit. Has listed because of.
So if a receiver has been appointed, is the lockout continuing?
As far as I know, lockout did not have been declared because his managers have service because of non-payment of salary. So they cannot be dispute between the managers and the owners because they have to dispute with the workmen. That was done by to bypass the division bench order where they had been directed to pay the amount of 5 crores which they had received from the for compensation of land compensation. To bypass that, they have just illegal and he had abandoned the car and then had declared lockout. So this he has done entire thing so that the money initially the petition was filed only on the pretext as soon as I get the land compensation amount, we'll pay the PL. Interim order was granted. When he received the amount, he has not been paid. Single bench directed the sum amount to be paid the entire amount. Division bench said not the entire amount, at least pay the demand amount, demand notice. After that, all this development has taken place.
Now lawsuit I will come to reply. What the PF authority is doing? Lawsuit after division bench of the division bench, honorable division bench granted 1 month time to this petitioner. Judgment was passed on 19th of September.
Anyways, your particular state is under attachment.
That is lawsuit, we have sent that.
I'm asking you, is it under attachment?
Attachment lawsuit, yes. As per the.
No, Mr. Kulita, Mr. Kulita, you see, when I was a lawyer, I did a lot of labor matters. So I'm asking you, is your company, is your state under attachment?
According to this petitioner, this is not attachment. This is a lockout. It is not under attachment.
You say it is not under attachment.
Yes, as per this petitioner laws.
Okay, file an affidavit then, that it is not under attachment. We'll have it on Wednesday. File an attachment that it is no receiver has been appointed, no attachment is given. So we'll see. Because if a receiver, if it is under attachment, then you have to make the PFR party. Because it is under their domain, you can't go for a lockout. Because once a receiver is there, you don't have a control.
This petition was filed 22 of September. It was filed in 22 of September.
Oh, so bad luck is there. So it comes before me after such a long time. It's a bad luck. No, it's a bad luck. It comes before me. So I'll do one thing. No. We do one thing. You should have. No case. Okay. List the because it came on 3110. List Mustafa. While the matter was taken up, Mr. R. Sharma, appearing on behalf of who is the standing counsel of the
PF.
what is that PF?
Provident Fund Organization.
What is the full name?
Assam Employees Provident Fund Organization.
Submits that the tea garden wherein a lockout has been announced by the petitioners is under attachment and a receiver has been appointed by the said organization. Mr. J. Kolita, however, submits that to his instructions, the same is not correct. Taking into account the above, list this matter as it. So based on 28/11/2025,
Can be after one.
Pustock, an additional affidavit be filed by the respondent petitioners as to whether the tea garden in question is under attachment of the Provident Fund organization and a receiver have been appointed or not.
Alright.
Yes, Mr. Hawk.
Same order.
Which package?
Ticket number 7, my lord.
Why didn't you give the name?
I think it was already listed.
Oh.
Last,
When did I fix the earlier matter?
26, my lord.
Huh?
26.
26.
Right.
Okay. Issue notice to correct to order আছে. Returnable 26. এইটো আমাৰ শিৱানী খুদিলে পাই যাব।
Hey, okay.
Yes, Mr. Gupta.
One of the order passed by the central government and industrial tribunal was under challenge. My lord, so far as the direction to pay the salary for previous month is concerned, my lord, we are not agreed by. But the part, my lord, by which the London tribunal has directed to pay retrenchment compensation, that we have challenged, my lord, on the ground that the employee was not a workman, my lord, given the meaning of the definition of the workman. Salary of the workman, my lord, admittedly from the record is, my lord, he was drawing more than 10,000, my lord, therefore, my lord, if I take, my lord, to the definition of workman, under section 2O, my lord, 2S, my lord, I'm sorry, my lord, section 2S.
Did you raise that issue before the
Yes.
tribunal?
Yes, my lord.
Where is it?
Page 27. Sorry, my lord, page 26, paragraph 1.
But kindly see paragraph 5.
Regarding the disengagement, my lord. Regarding disengagement, my lord.
No, you read it.
No, no.
Paragraph 5
With
properly.
regard to the amendments made in para 5 to 7, it is stated that the same has already been replied in para 4 above. It is further stated that the competent authority has informed the.
No, paragraph 5 of page 34.
That the second contention of the management of ASI is that the petitioner was engaged as a daily wage casual worker on muster roll of establishment up to May 2017. The engagement was need-based and no letter of engagement was issued to her. The petitioner was thereafter engaged in consolidated remuneration from June 2017. Payment of remuneration was made by issuing hand receipts. It is asserted that all the payments have been made to the petitioner for the period 2014 to January 2020. She was verbally intimated for her disengagement in January 2020, as there was no requirement of work. It is asserted that the Archaeological Survey of India did not violate any provisions of the ID Act 1947. The employee is neither entitled to any area pay, retention benefit, nor any bonus, as she had been working as casual worker. It is contended that an employee is entitled to bonus only if she worked for at least 206 days in office, following 5 days a week in each year for 3 or more years, as on 31st March of the relevant financial year. The management urged that the petitioner employee is not entitled to any relief, and the present case is liable to be dismissed.
So where is your stand? Your stand is that she didn't do work for 206 days. That's your stand. Now you are coming into a different stand, that she is getting more salary.
But that is the statutory requirement, my lord.
That is the statute, you should have raised
Definition
it
of
there.
Workman, my lord,
I don't interfere with this type of whatabouts.
my lord, at page 37, that the fact is admitted that my
Where?
lord, more than 15,000, my lord, she was drawing. She herself has got it by way
Where?
of evidence, my lord. Page
In
30,
cross-examination
page
paragraph,
37. Page 37, my lord, first line. On
he
his
admitted the fact that
examination-
Teresa was engaged at ASI from Iman to Iman, and thereafter she was engaged as casual worker on temporary basis from Iman to Iman on a consolidated pay of rupees 15,000 per month. Subsequently, on consolidated payment 18 from July to year. It transpired from his evidence that the competent authority did not accord sanction for continuation from February, and her service was without any notice. You should have raised that issue. Why haven't you raised some industrial disputes, sir? Now you are agreeing with what?
My lord, so far as back wages for 3 months, which we have not paid, we have already paid. Only that part, my lord, by which the tribunal has held that the employee would be entitled to retrenchment compensation and 1 month pay.
No, Mr.
That part.
Gupta, the thing is like this.
Hmm.
If you, if the court, the tribunal did not have a jurisdiction, then that thing goes. But if the tribunal has the jurisdiction, then everything remains. So you have to therefore satisfy me as to whether the tribunal has the jurisdiction or not. You say that she was not a workman. Why? What is the definition of workman? Let us see.
Yes, my lord.
Yes. Where is it?
Workman means, my lord, any person
Who
employed.
being employed in a supervisory capacity draws. She's not employed in a supervisory capacity. She was not there. This 4 will only come when a person is employed in a supervisory capacity. Draws wages exceeding 10,000 per mesem or exercises either by nature of the duties attached there by reason of managerial status. So are you therefore, is it your case that she was employed in a supervisory capacity? That is also not there.
Skilled, my lord, highly skilled worker.
No. First of all, this 10,000 will only come when you have the first satisfaction that he or she was employed in the supervisory capacity. Is there any evidence in that regard?
Any workman, my lord,
No. Not any workman.
being to be under a supervisory capacity.
No. How can the be on a? Show me. What is this? Which paragraph?
My lord. Paragraph 7, my lord, it is submission.
You have employed her as a daily wage worker, and then you have just made her a consolidated remuneration and so and so.
No.
She's a worker. Where is the question of supervisory?
Initially casual worker.
No,
and
here
after
you
to-
see, this
No, no.
person was an assistant engineer. Then, as per the letter of the manager, the employee was promoted as assistant engineer E&C in Group 2A with effect from N, and his revised salary was so and so per month. The services of the employer was confirmed with effect from so and so, so and so. The law is well settled that it is a principal duty and function performed by the employee in the assembly and not merely the designation. Further, the onus of proving that the employment rests on the person claiming to be a workman within the definition. There is no specific document introduced relating to the actual work and function performed by the employee in the absence of any concrete material to demonstrate the nature of the employment. Orders issued by the EA will have to be taken into account as per se, and was appointed as a junior engineer and was appointed as assistant engineer on the administrative side. So, how do you have this? That case.
Nature of function knowledge she was performing, the nature of function she was performing was in the category of a highly skilled.
Where is it?
worker. That's the observation note at page 46. The court himself has admitted, Malad, it is manifestly clear, page 46. Malad,
Of the?
Of this petition, Malad.
Yes.
It is manifestly clear from the exhibit M1 and M2 that the employee had served at ASI as highly skilled casual worker on consolidated pay, which was temporary in nature. The employee was not engaged against any sanctioned post, substantive post, nor selected through established selection procedure. Under such circumstances, the employee is not entitled to the relief of reinstatement under section 25H or back wages for the period during which no service was rendered.
In view of above discussion, the industrial dispute raised by the employee is allowed on context. The management is directed to pay the above aforesaid retrenchment compensation, which is equivalent to 15 days average pay so and so.
On the one hand, Malad, the termination was held to be legal. But on the other hand, Malad, the tribunal directed a retrenchment compensation. Both, Malad, cannot go together because first criteria of workmen, Malad, was not.
A retrenchment compensation has been allowed only on the ground that this particular person concerned was he was against a non-substantive post.
The definition of the workman has to be fulfilled, Malad. That has not been fulfilled.
But where have you raised that? Unless you raise that issue, why is the question of evidence? Problem lies there, na?
That is the statutory requirement.
First of all, when it is being there, you have to raise something. Where is your affidavit? Yes. Your affidavit is filed by the year. Is not maintainable before as the workman has not approached it with clean hands, neither in industry. You have not raised those in your written statement also. Not a single word that he was working. Your basic case is that he was not working. He was just a casual employee, casual daily rated worker. And therefore, he used to, whenever we want them, we use them, and we accordingly, whatever amount was there, we have paid them.
For that reason, the termination was not interfered.
No, therefore, the question of termination also does not arise that whenever we wanted them, we have taken them. This is what you have stated in this paragraph. No? Kindly see paragraph number 3, page 24. The applicant was engaged for different periods of work between the year 2014 to January 2020, for which the payment has been cleared to the entire period she has worked with so and so. Thus, the instance is an abuse on so and so. But whatever may be, the question is you have raised another issue that whether the applicant has done 260s, which is another requirement of a temporary employee. This is a requirement out there. Where is that? I saw it somewhere. To be an employee, one has to be working employee. 206 days, employee. Where's the definition? Employer. Where is that thing? It requires 206 days you have to work.
25, section 25, definition of continuous service.
25. For a period of 1 year, if the workman during this period of event preceded in which he has actually worked under the employer of not less than 190 days in the case of workmen employed below ground in a mine, and 240 days in any other case. So was this proved?
Look, initially she was a casual worker.
But was this proved that 240 days?
So that was not true, my lord, because
No, that is proved.
we could not produce the report, page 42. In the middle, my lord,
She started working as ASI for Miman as a skilled casual labor on consolidated pay and experience. Certificate was issued to her, which was exhibit. She further stated that she performed various types of work and received her consolidated pay of rupees so and so per month for the month of Iman, which have been supported by her bank statement so and so.
was simply a contractual employee under the department, my lord, and not an industry sector.
That is another aspect.
My lord, that we also we have taken that.
That is another. You may say on that whether it would come within the definition of industry, but
That is also-
come under 2S becomes a difficult thing. Because to say that she was earning that, okay, let us issue notice, let us have it. But no stay. Issue notice making it returnable on 8th of January on 7th of January 2026. Steps be taken as upon the respondent by way of speed post. In addition to that, the petitioner is also directed to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner herein have assailed the award dated Why you have approached this court so late? When was this award not notified?
The date of notification is not.
Huh? Has the award been notified or not?
It has been notified, my lord, but the date, my lord, I am not having this. The award I am having.
No, why then you have moved this course after such a long time? You moved this court after 1 year.
Petition was. On page 47.
This is certified copy. You have taken it later. Have assailed the award dated 28-10-2024, passed in reference case number 12/2020. On the ground that the learned Central Government Industrial Tribunal cum Labour Court Guwahati had erred in law as well as in facts in holding the petitioner to be an industry within the meaning of section 2 W. What is that? Work industries 2J of the Industrial Disputes Act 1947. The learned counsel appearing on behalf of the petitioner further submitted that the respondent having received admittedly rupees 18,000 per month, the respondent could not have come within the ambit of workmen as defined in section 2S of the Act of 1947. In addition to that, the learned counsel also submitted that in terms with section 25 capital B, it is of the Act of 1947, it is the requirement that to come within the ambit of continuous service, the respondent had to work for not less than 240 days, which the respondent have failed to prove to be entitled to the relief as sought for. Full stop. This court heard full stop. Taking into account those submissions, this court have issued notice. Full stop. An attempt shall be made to dispose of the writ petition on the next date. The registry is directed to requisition the records from the court, from the learned Central Government Industrial Tribunal cum Labour Court Guwahati, and ensure that the said records are available before this court on the next date. Full stop. Additionally, this court keeps the maintainability of the writ petition on the ground of delay and latches open, taking into account that there is no justification given as to why the instant writ petition has been moved after almost 1 year from the date on which the impugn award was passed. For the sake of clarity, this court observes that there is no stay to the impugn award. Yes, Mr. Sharma. Non-payment. Chalo. Non-payment. 16 February. Filing affidavit by 9 February. You take notice for everybody.
Yes, sir. E-voter letter.
E-voter.
Lordship, 2005 voter list. Page 25 and 26.
Who is paying? ECI? You are ECI? What do you say? Why have you made them a devoter? Huh? Where is that order? Disposed. Give the details. Which constituency?
Yes, please. Subsequently to filing of the writ petition, the order that we are challenging at page 47 has been withdrawn. And he also been appointed. There is
What?
subsequent to filing of the writ petition,
Ah.
The impugn order has been, my lord, recalled.
Transfer and posting of on a process server against the vacant post of process server in so and so.
So,
is
it becomes
hereby
infructuous.
issued by the money hereby recalled and cancelled and so and so. Directed to continue in its. Okay. Therefore you want to withdraw the writ petition.
accordingly, if your lordship may dispose accordingly with the.
You are challenging a transfer.
It was not a transfer, lordship, because selection process was going on. During the election, the selection process,
Transfer,
the notification was passed for a transfer of a particular person from the Sibsagar to Guwahati Amingaon. And later on, when we have challenged the writ petition, the subsequently it was being withdrawn. He was working with the Amingaon itself,
Where is that order? 411?
47,
Huh?
47.
Okay, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. H.K. Das appears on behalf of the Guwahati High Court. The petitioner herein have assailed the order dated 4/11/2025, passed by the Register Vigilance, Guwahati High Court, whereby the petitioner, who was serving as the process server in the office of the District and Sessions Judge Dima Hasav, was transferred and posted against the vacant post of process server.
no,
With
he
the
is the
establishment
respondent,
of the member MSCT Kamrup Amingaon. Good stop. It has been submitted by the learned counsel appearing on behalf of the petitioner that a cause of action for the instant writ petition no longer survives, taking into account that the impugned order dated 4/11/2025 have been recalled by then another notification dated 7/11/2025. The said notification dated 7/11/2025 was placed before this court, which is kept on record and marked with the letter X. Taking into account the above, nothing further survives in the instant writ petition, and accordingly the writ petition stands closed.
respondent number 4 has been transferred by this notification. By page 47 notification, respondent number 4 has been, was transferred, not the petitioner, my lord. Lordship
Is it?
recorded petition. Yes, my lord.
Then why is he challenging?
So this was challenged because the respondent number 4 was, my lord, posted in a post wherein he was aspiring promotion. The post of process server wherein the respondent number 4 was transferred, against that post, he was aspiring promotion and that was recalled.
Who is Anup Thakuria?
He is respondent number 4, my lord.
Okay. Whereby the respondent number 4 was transferred from the post of process server to the district and session judge Dima Hasav. 4/11, huh? Against the vacant post of process server in the establishment of member MACT Kamrup Amingaon.
Yes, my lord.
The learned counsel submits, then in the meantime, it has been recalled.
My lord. Highly. Okay.
7.
And where is this? There is another one, a member MACT attached beyond.
Appointment. One is the withdrawal and other is the appointment, other which he has been.
And the petitioner has now been appointed.
Yes.
So it is further stated, and heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. H.K. Das appears on behalf of the Guwahati High Court. The petitioner herein, who was aspiring to be appointed against, promoted to the post of
Process server.
process server in the office of the member MACT Kamrup Amingaon, was aggrieved by the order dated 4/11/2025 issued by the Register Vigilance, Guwahati High Court, whereby the respondent number 4 was transferred to the said post. It is being submitted that pursuant to the filing of the instant writ petition, the impugned order dated 4/11/2025 have already been recalled. And in that regard, have placed before this court the notification dated 7/11/2025, which is kept on record and marked with the letter X. Accordingly, nothing further survives in the instant writ petition, for which the instant writ petition stands closed.
Hello.
Yes, what is this?
There is a case when the husband of the petitioner, my lord, died in electrocution, my lord. Accordingly, my lord,
Electrocution is here
maybe
in this court, bench 5, na?
five. That's five.
Divisional Engineer Bilasi Parad. Anyways, why should I have your agony for? Okay. Issue notice making it returnable on, how much time will you take, madam, for getting the electrical accident report? Okay, issue notice making it returnable on 7th of January 2026. Mr. So-and-so?
W. Ahmed, madam.
Now, Ms. So-and-so accepts notice on behalf of the respondent number 1
And 6. And 6, ma'am.
and 6. Mr. So-and-so accepts notice on behalf of
225.
respondent number 225. The petitioner herein is aggrieved by the non-payment of the compensation. For the unfortunate death of her husband, who allegedly expired on account of an accident of electrocution. So the petitioner sought for compensation before the respondent number 225. However, no compensation was paid, and it is under such circumstances the petitioner is before this court. To stop. Ms. So-and-so appearing on behalf of the respondent number 6 is directed to bring on record the electrical accident report on or before, by 5th of January 2020, on or before 5th of January 2025.
Item 8.
In this case, I have limited grievances, but I have submitted a application before the authority for issuance of delayed death certificate.
What?
Delayed death certificate. My father died.
Death certificate?
Yes, madam, in the year 1994. And I have submitted the certificate issued by the Gambura. And now they are insisting upon to submit the doctoral certificate since my father died at home. So,
What is this delayed death certificate?
because it should be applied within prescribed limit, my lord, since my father died in the year 1994. And I have submitted the application in the year 2020.
Why? Now you have submitted?
Yes, ma'am. I have submitted, they have raised an objection that I should submit a doctor certificate since my father died at home due to natural cause of death. So I am unable to submit a doctor certificate. I have submitted representation, and on the basis of my representation, the assistant commissioner also written a letter to the district commissioner stating that at this situation, what to do. Page 35. In the light of the above, I therefore request your kind guidance, direction, if a Gambur Pradhan certificate can be considered as an alternative document in regard to issuance of permission for delayed death certificate for such cases. application is still pending, my lord.
Why do you need a death certificate of your father after such a long time?
My lord, for mutation of land, for partition of land, death certificate of my father is required, my lord.
Partition of land.
And mutation of land, then we have to produce the death certificate of our father. That is the reason is explained, my lord, page 33. The reason for the issuance of death certificate is to apply for next of kin application certificate and for the
Page?
page 32. This is my representation before the deputy commissioner, district commissioner, and page 33, reason for respected, sir.
But Lordship, page 32 doesn't bear any seal and signature. Page 32 is addressed to the district commissioner. It bears no seal and signature.
On the,
Acknowledge or not.
my lord, on the basis of that next page, next page.
Page 34 also, Lordship, it doesn't seem to be a comment.
No, page 36, this is the sign, signature, bottom page. Assistant Commissioner, District 4. As per my representation, the Assistant Commissioner has written. It was a signature, right? 36.
36
But then also page 36 is the,
36 is not available. 36 is not available to us.
what?
Maybe this is a type copy, it is
Page
original.
36 is not.
You have not given him.
My clerk may miss,
Give them.
or 2 PM, my lord.
No, why? Where is your page 36?
My lord, only type copy and the original.
You have the page 36.
Yes.
Give it to him. And you take his page 36.
Same, my lord.
You take his petition. Hey, Mr. Bolwa, kindly give him his petition. Give him. Give it to him.
Extra
Page
copy,
36.
yes.
No, your copy, you give it to him.
Yes.
Ah, yeah, you got it.
Yes.
Now read page 36. Yes, read. No, don't take it from him. How will he know then?
Yes, my lord, I have extra copy.
Therefore, you were supposed to give him a copy. Your main document is page 36, isn't it?
36 the original and 34 is the,
Mr. Counsel, your main document is page 36.
I have given, my lord, extra.
Ah,
copy.
now you have given good.
Then page 35,
35 is nothing. It's type
then
copy.
36.
36.
Yes, my lord. Last.
Okay, what
the
is
light
the
of-
so? Yes, health. What do you do? Obviously, you can't do anything. You can't do anything because he died in the year 1994. Now he wants a certificate in 2025. Now he remembers that some land is required to be partitioned. Now you must be having something, or if it is not there, something has to be worked out. You appear for the registration of births and deaths. Okay, you are a party here, no? Okay, because from your side, this is very relevant. There, I think that you have some notifications issued. That what happens means within what time you are to apply and all these things. This is
Page
there.
20 is the guideline.
Then what happens? Anyway, you should notice making it returnable on 9th of January 2026. Miss Deborah appears for the respondent number 1, 2, and 3. Mr. S.R. Bolwa appears on behalf of respondent number 4, 5, and 6. Extra copies of the writ petition be served upon them during the course of the day by tomorrow. The petitioner, the case of the petitioner herein is that his father expired on 1/8/1994 in his own residence, and the cremation was done by the villagers were done by the villagers. Full stop. On account of mutation, partition, as well as various other reasons, the petitioner had requested for a delayed death registration of his father by the communication dated 23/7/2025. However, on account of there being no doctor's certificate, the said application have not been processed. It is under such circumstances the petitioner is before this court. The respondents are directed to bring on record their stand by filing the affidavits on or before 5th of January 2026.
Representation as well online application that maybe. Online application dated 26/2025.
Online application dated 23/7.
206/20 June 25. It's 24.
Online application dated
26/2025.
2020,
5.
2025.
It's not submitted to the health department.
It's a online application. Portal, online portal.
Done it in the portal.
Portal.
And there is again a representation to the district
Yes.
commission, but nothing to the health department. No, but it is not, he will get the death certificate not from there, it will be given from this particular, by the, under Seva portal.
Seva portal.
But you are to, but isn't it required to do it before the registration of births and deaths? No,
He has to apply lordship first.
he has to apply before you. Isn't it?
So, number 3, he has to apply.
You have to apply before him only.
This is-
So, as per
It is
on the
online application.
online application. Nowadays, my lord,
Nowadays, it has to be applied through online for death certificate
so
and
the-
supported documents to be
I have,
enclosed.
filed an application on 26/2025 and also to give
represent.
in the online mode as well as representation on 23/7/2025. However, both the representations, however, the application has not been processed on the ground that the petitioner have not been able to provide the doctors, the death certificate of issued by the
Doctor
doctor. Considering the above,
the person.
the
Application number 29.
Is a tea state, my lord. Admittedly, we have committed default in payment of the, my lord, provident fund. Now, if the lordship would kindly have a look at the facts. My lord, there is dues, there is a certificate of demand, we are not disputing that. Now, my lord, I'm not even taking your lordships to the earlier part. If your lordships would kindly come to page number 59, my lord. An order was passed. It was on 29th of October 24. Grant of installment against area amount of PF dues in respect of Koliabor Tea Estate. Your letter dated so and so. With reference to the above, I am directed to state that the Honorable Chairman Board of Trustees, on consideration of all facts and circumstances and on your written representation referred above, is pleased to pass an order as follows. Kindly come to 2, my lord. The deposit area provident fund contribution amounting to 2 crores and odd for the period from 29/11/21 to 36/24 in 36 equal installment at the rate of 6,37,000 with effect from October 24 positively. Then in this connection, you are hereby requested to submit necessary post-dated checks towards payment of the aforesaid 36 monthly installment within 15 days. My lord, at page 61, what the petitioner Tea Estate did, my lord, instead of 36, they deposited, my lord, 24 post-dated checks of 9,56,000 each instead of 6,35,7,000. End of the day, my lord, 24 installments covers those amounts. So instead of 36, we said that we'll make payment in a 24 installment and we tendered the checks also. Then all of a sudden, my lord, a notice of recovery is given at page 63.
And before that, my lord, earlier arrangement was cancelled on 24/3/24, 24. Cancellation of installment against area PF dues. With reference to the above, I am directed to inform you that installment granted earlier white under reference is hereby cancelled with immediate effect. And the checks were not returned, they retained the checks. Then the next page, my lord, they come up with a new proposal, notice of demand. Now you are hereby required to pay the aforesaid amount within 15 days from the date of serving of this notice. Now the amount goes up to 5 crore and odd.
Okay. Why they cancelled the early one?
No reason.
Okay. Then,
We tendered the check, my lord. Then, my lord, these things continued. Then, my lord, there was a hearing. Then in the hearing, my lord, in the hearing, nothing happened. An order was passed on 5/8/25. Against that, we filed an appeal before the appellate authority. And appellate authority, my lord, passed the order on 119, my lord. And before that, my lord, they also attempted to make an attachment of the, my lord, our
kindly come to
property.
Annexure 15.
My lord,
Annexure 15,
yes,
5/8/2025.
yes, 87, page 87.
Yeah, kindly see the last paragraph of that. Earlier, the privilege of installment.
Now, page 88, my lord.
Now, 87, you get some
Yes,
reason.
yes. Earlier, the privilege of installment to deposit PF dues payable for the period from so and so to was given and was allowed to deposit the arrear in 12 installment. But shockingly, all the 12 now submitted by, but this was earlier, my lord. This was in 22. Thereafter, they gave us 36 installment. Instead of that, we deposited 24 post
No, no, then you further see, every time,
No, my lord, this is, they're referring to the earliest.
no, no, you kindly see. There are-
Yes, my lord. Every time you were granted installment to deposit the arrear dues, you deliberately failed to deposit the same in time. Moreover, in order dated 29/10/24, you were specifically asked to deposit arrear dues in 36 installment with effect from October 24, but you submitted post-dated checks with effect from, and further you deliberately did not submit post-dated checks from November 5. This is not correct, my lord. 24 checks you have deposited.
No, it was deposited from some other period.
No, if your lordship would kindly come to my lord.
No, you were, no, kindly come to page 59.
Yes, 59.
You were asked to submit this 36 installments from October 2024.
Yes,
You
Yes.
gave the post-dated checks from 30 April 2025. That is the
no,
reason.
my lord. Ultimately, that earlier the installment was 6,35,000, but we paid checks of 9,57,000. So entire amount was covered. Page 61. And similar. End of the day, 2,02,29,000. Page 61. Yes, it was from 30th April, but the amount is same, my lord. Because earlier they fixed an installment of 6,37,000. We paid 9,53,000.
And you were asked to submit those checks on or before within 15 days.
Yes,
You did it on 10th of January 2025. That
Yes.
is much after that period.
true, that is
Yes.
correct.
So that must be the reason why.
But at
Okay.
the end of the day, my lord, under the act, even if a certificate is issued under section 15 capital B, the recovery officer can always grant time, my lord. Provision is there.
Okay,
Now,
now what is
what
the
good
page
reason-
88? However, to deposit the PF amount cost of rupees so and so for so and so to so and so within so and so to deposit the DLI amount to deposit so and so for the period from so and so. The statutory advised to deposit the above failing which
ultimately,
whether you are directed to submit 20 it is to numbers of dated checks for a So you are being asked to pay in 12 monthly installments?
Now, instead of 36, it has come to 12. What is that good reason, Milord?
No. There is a reason why.
Yes,
Here you kindly see number 4.
yes. To deposit arrear PF contribution amounting to 2.81 crore payable for the period from so-and-so to so-and-so in 8 equally monthly installment of 35 life per month with effect from August 25 positive. So, my lord, kindly see.
Then another amount, so this is 8 plus another 5 is interest.
5. That is statutory interest.
Yeah, so 8 plus 5. So therefore you have this total is 5 crores something.
It is
no?
something less, yes.
So
Now, my
therefore
lord,
you
my
have-
humble submission is
Hmm.
your offer of 10,125, why you have to change? We have deposited. What is that good reason? 10,125, they said you deposit 36.8. Sorry, 29.10. Then what we did on 10,125, we deposited 24 checks covering the same amount. Now 15% is the statutory
But
interest.
Mr. Chaudhary, isn't it when you are given a particular benefit of an installment payment,
Yes,
then you are to abide by the terms. You were asked to deposit within 15 days from 24/10/2025.
29,
You,
yes.
yeah, you submitted on 10/1/2025. Did
10
you ask in the meantime, give me some more time for depositing of the installments? These are, you see,
I appreciate, my lord. Lordship will not be take such hyper-technical approach here, my lord. End of the day, the industry as a whole is undergoing a very bad phase. And the statute itself, if your lordship will kindly have this section 15 capital B, my lord. I guess it's better. এইটো ক'ত গ'ল? এই যে হেৰি দিব পাৰে যে। Please come to my lord 15 capital E at page 250, 243.
yes.
On top, notwithstanding the fact that a certificate has been issued by the authorized officer to the recovery officer for recovery of any amount against plantation or employer, the authorized officer may grant time for payment of amount, and therefore thereupon recovery officer shall stay the proceeding until expiry of time so granted. So, my lord, there is a statutorily prescribed discretion given to the, my lord,
Authorized officer.
recovery officer. Now, all that.
No,
he's
no, no.
saying
It is being given to the authorized officer,
Yes,
not to the recovery officer.
no, my lord. The authorized officer will issue the, my lord, certificate. Then the discretion has been given to the recovery officer.
No, the authorized officer may grant time for.
Yes, yes.
So the
Correct,
power
I'm
is
sorry,
given to the
sorry, yes,
authorized officer.
correct. No, all that I am saying is, my lord, we are in area. It's not that we have a crystallized right or something. End of the day, lordship is also a court of equity. Now, all that we are saying is, you have given us time. We have tendered the post-dated checks. It is not your case that any of the checks have bounced or it has not been honored. Now, what prompted you to come down to 12 installments? It's not possible, my lord. And the statute itself is such where a leeway has been kept for the authorized officer to take a call.
And why you have enclosed some Supreme Court judgment order?
No, my lord, there the Supreme Court gave some time, my lord. All that we are saying is, my lord, we'll follow that schedule strictly, my lord.
No, now too you cannot follow that, taking into account the interest have accrued.
No, my lord. Question is, serial number 5, that is 15% interest component is another 2 point odd. So, my lord, that aspect lordships will finally consider at
I
the time
cannot,
of
that
hearing.
that is statutory, na?
No,
Can this
I-
court, can the court reduce it?
My lord, today what is happening is, my lord, this Provident Fund Authority, their idea is to sell this garden. Next step, what they will do and who will buy, we all know, my lord. And who all are the receivers who are being appointed? My lord, I am dealing one case from Kasar. There the due is about 3 lakhs and not 3 crores and odd. Now they have received an receiver, my lord. It is shocked to learn, my lord, he will the capacity is 41,000 kilo. Now he will pay 2 rupee per kilo. That way, my lord, he will take about 9 years to, and he's not paying anything, but he has been appointed as a receiver. Whereas the, my lord, the party, he is prepared to pay, clear the entire dues because he is getting some compensation land, compensation for acquiring tea garden land. And my lord, it will be done in 60 months. But they're prepared to give 84 months to the receiver. And receiver is not paying anything. They're happy. Now this is how they're functioning. Now here in this
No,
case,
Mr. Chaudhary, I am these are, I also know, I've seen it, that they do whatever they feel like. And there is another aspect to the matter. You see, tea garden, you can't transfer it.
correct.
The best mode is the PF, how you do it. PF gives you and you run it. And if you see these agreements are also, these are in eternity. These are there. That is one aspect of the matter. But the other aspect is, the court cannot reduce the statutory interest.
No, I'm not saying lordship will reduce the statutory interest, my lord. For the present, my lord will continue to pay according to that. Lordship will kindly protect us. They will not take any coercive measure in the meantime. We'll pay as per that, my lord. 2019, 24 will continue to pay. They said you pay in 36 installment of 6,35,000. We are prepared to pay at the rate of 9.56 lakhs. Lordship may increase it to 10 lakhs.
But what about the interest?
Interest part, Lordship will take care at a later date. my
That,
lord.
how can I do it?
And then I can start paying, my lord. End of the day, you have to pay, I'll pay. Interest part, my lord, let them give some time, we'll pay. And we have made that prayer also. Lord. My lord, it is our garden. We can look after the interest much better than any receiver or somebody else. But Lordship knows in all this deal, arbitrariness often creeps in. Therefore, I'm making it very clear, my lord. I'm not saying that I've got a crystallized right or something. It is only in equity I'm playing some relief, my lord. Interest also, I cannot escape that liability, but some time is required, my lord, so that I can save my property.
No, you cannot go back to 2910. 2910 cannot be gone into.
Let them-
2910 is
My lord,
over.
let them-
But
let them-
2910, they have not charged interest. Yes, why didn't they charge interest in 2910?
Lordship wants 29 notice, last paragraph, your lordship.
My lord, can I make one submission, my lord? Within 15 days from today, we'll deposit an amount of 25 lakhs. And let them, my lord, work out the schedule, my lord, afresh. Having some continuity of the 2910 thing, my lord, we'll continue to pay. Immediately, we'll pay 25 lakhs within 15 days. And thereafter, let them fix the installment. They want the money, we'll pay, my lord.
Let me hear you.
Yes.
Chief, see the last paragraph of page 59. It says the position will be reviewed again if the management fails to submit the said PDCs within the stipulated period of time, and the installments so granted will be withdrawn forthwith and necessary recovery proceeding will be initiated. So accordingly, since they had failed to pay within the 15 days,
No, without reading that also, I know.
yes,
When you give them a scope of depositing in 36 installment, that is one. But my only question is why there was no interest involvement in Annexure 4?
because till that time, your lordship, the demand notice was not issued. We have issued the demand notice after withdrawing this scheme because they were area PF also. So we had only asked for paying the PF that time. But if your lordship sees, we have issued the demand notice at page 63.
Page 63.
Yes. It starts and 64 is an annexure. So on this basis,
Now tell me, who can issue the demand notice?
Certificate officer.
the authorized officers inform the recovery officer and the recovery officer then issues the demand.
No, it is done by the recovery officer.
Yes, done by the recovery officer.
But where is the authorized officer?
A demand notice is issued by the recovery officer.
Can it be issued by demand by the recovery officer?
Yes.
Where is it? Which provision?
Your lordship may see 15B1, if it is in that.
Yes, so it is by the authorized officer.
Authorized officer will inform the recovery officer, and the recovery officer.
No. Where any amount is in area under section 15, the authorized officer may issue to the recovery officer a certificate. So the issuance of the certificate is by the authorized officer, not by the recovery officer. Because if you otherwise, that is why Mr. Chaudhary was also submitting and 15E. 15E, the power is given to the authorized officer to grant installment, not to the recovery officer. This is very important. It is like the court and the executing court. Isn't it, Mr. Chaudhary?
It is the authorized officer.
Huh?
It
So
is
it
the
is
authorized
the
officer.
authorized officer who will do it. It is his power, not the recovery officer's.
That's why it says issue of certificate to the recovery officer.
And therefore, the 15E,
Huh.
as you were reading,
Yes.
gives the power for giving installment to the authorized officer, not to the recovery.
Direct recovery officer
Yeah.
to act according.
And the recovery officer will stay.
Yes.
That I'll come.
It's because why I'm saying your entire basis.
Yes.
Why therefore I asked on 2910 or 2410, the authorized officer gives a power that let them go and give an installment. After that, within that period, they don't do so. So obviously that communication becomes bad. They give it later on in the month of January. Then what you do, you cancel. This is being cancelled by the secretary come PF commissioner, means you cancel, the authorized officer cancels it.
Yes.
Then the recovery notice is being issued by the certificate is issued by or the recovery notice of demand, is it based upon the recovery office? Please take note of that the certificate number so and so have been forwarded by the, yes. So therefore it is the authorized officer who have done it.
This is forward.
So therefore his authorized officer has done it. Where is this document?
This I'll bring by way of an affidavit. If you.
So this is begun by? Now, Annexure A is signed by the recovery officer. Kindly see
Even
this.
Annexure 7 also, my lord.
Please take notice that the certificate number has been forwarded by the authorized officer for recovery of the year, which are given in the page 2, Annexure A. Then there is a hearing.
Yes.
Your lordship, the order that you have seen in page 87, this, they have referred an appeal to the appellate authority, and the appellate authority has further extended the time. The
Yes.
yes, your lordship will find at page 125, the 8 months has been extended to 10 months, and the 12 months,
10.
yes, 10, and the 12 months to 14 months.
So first they have to deposit for some 50 lakhs.
Yes.
2.81.
No, kindly come to page
ABC.
125
Yes, my lord. D.
to deposit the entire within 31st.
Yes.
Yes.
So to deposit PF administration amounting to rupees 13 lakhs so and so for the period from so and so to so and so within a month. Entire DLI dues within so and so to deposit so and continue to pay the regular so and so. Now they have also given this 2 lakh 28 and another 18, which comes to around
2.8 crore.
44 lakhs. Almost 44 lakhs, 46 lakhs. 46, 47 lakhs per month.
From 6,37,000.
Lordship, may I kindly see paragraph 3 and 4.
So, Mr. Chaudhary, how do you intend to pay? Where is the money?
No, that's why I'm saying, my lord, within 15 days, we'll deposit 25 lakhs.
No,
And
25,
thereafter,
25 is too less.
no, we'll start paying, my lord.
No, 25 is too less. Within 15 days, I'm giving you, I'm asking you to pay within 15 days, you have to pay not less than 50 lakhs. No, because you are to pay otherwise that amount. Plus, you are to actually pay within 38th of
My lord,
November 1 crore.
can I make a submission, my lord?
Yeah.
We'll pay 50 lakhs within 1 month, and thereafter they will, my lord, reschedule the thing, we'll pay. 50 lakhs within 1 month, and the rest, my lord, monthly installment, they will reschedule. my lord.
This.
End of the day, they want money, we'll pay.
There's also
If we don't
gratuity
pay, our
amount to be
guarantee
paid
is
also. So I have received instructions that gratuity amount also has to be paid around 2 crores something. So they huge default, which is not here. And the current dues also they are not paying as for paragraph 4.
Let's have the matter on 17th of December. In the meantime, by 15, let them pay 50 lakhs.
Yes,
And then you will talk
yes.
how you can do anything,
Yeah.
can be done anything. Because if there is an industry, it can be done something, it's okay. Let them pay 50 lakhs and the stay is only 10 till 17th.
My lord.
Thereafter, if they don't, then again we ask them to pay. But anyways, if one has to liquidate the entire amount per month, first therefore, let us see that we are granting them an extension only. Nothing more than that. This amount so that first let this thing be clear. Number C.
And if your lordship, A also, if it, A and C. Because B is also there, but at least A and C.
How much is this? A, what is A? How much?
This is around 13 lakhs 65.
Okay, it's 49 plus 13. 62. Let them pay. I'm giving them an extension for 15 days. Let them pay, we'll take it up later. Issue notice making it returnable on 17th of December 2025. Mustafa. Who appears for this? Principal Secretary Labor. Yudas appears on behalf of respondent number 1. Mr. R. Sharma accepts notice on behalf of respondent number 226. The petitioner herein, extra copies of the writ petition be served during the course of the day. The petitioner herein have assailed the orders dated 10/11/2000 or order dated 10/11/2025 issued by the Secretary cum PF Commissioner Board of Trustees, issued by the Chairman Board of Trustees, Assam Tea Employees Provident Fund Organization, whereby the petitioner have been directed to make the following payments. Paragraph 7, which is mentioned in paragraph number 7. And the same is reproduced here in under a paragraph 7 to quote query. Mr. Kane Chaudhary, the learned senior counsel appearing on behalf of the petitioner, submits that the petitioner have all intention for clearing all the dues which the petitioner is liable to pay as per the statutory requirement. He, however, submits that taking into account the present situation of the tea gardens, comma, the entire the tea garden, comma, it would be next to impossible for the petitioner to deposit as directed in the order dated 10/11/2025. He submits that if there such a steps is allowed to be continued, it would not be equitable, taking into account that it would amount to closure of the petitioner's tea garden, or that said tea garden would be handed over to third parties. Thereby, it would be causing irretrievable injury to the petitioner. That's your submission.
Yes.
Full stop. Per contra, Mr. R. Sharma, appearing on behalf of the respondent number 226, submits that the petitioner is a habitual defaulter, and as such, in spite of various opportunities being granted, the petitioners have not cleared the dues and have been approaching this court as well as the various authorities so that they can just delay the making of the payment. He submits, therefore, that the petitioner is not entitled to any equitable relief in view of the conduct of the petitioner. Full stop. This court have heard the learned counsels appearing on behalf of the parties on the question of whether there can be any interim directions being passed. Full stop. Mr. Kane Chaudhary, the learned senior counsel, submits that to show that the petitioner has the right earnest to pay the statutory, to pay the dues as per the statutory requirement, the petitioner is ready to pay certain upfront, make some upfront payment till the next date, so that the respondents authorities can further may revise the schedule as regards the payment of the outstanding dues. Full stop. He submits that the petitioner is ready to pay an amount of rupees 25 lakhs till the next date. Full stop. This court heard the learned counsels appearing on behalf of the parties and have also perused the materials on record. It is seen from the materials on record that earlier the petitioner was given an opportunity to make payment by way of installments by an order dated 29/10/2024, subject to the petitioner depositing 36 checks, post-dated checks at the of rupees 6,37,232.74 paisa with effect from October 2024. And the said checks were to be deposited within a period of 15 days from the date of the said order. However, it is seen that the petitioner did not deposit the said checks within the period of 15 days, but in the month of January 2025, the petitioner deposited 24 checks of rupees 9 lakhs, 23 checks of rupees 9,56,000 and one check of rupees 9,52,378.36. Full stop. The learned counsel appearing on the senior counsel appearing on behalf of the petitioner had submitted that the petitioner would have no difficulty had this thing been continued. And instead of that, the same was cancelled. and thereby burdening the petitioner with such a huge amount. Be that as it may, it is the opinion of the court that certain upfront payment has to be made. And the amount, and taking into account what has been directed in the impugned order dated 10/11/2025, it is the opinion of this court that an amount of rupees 13,65,180.52 plus rupees 49,60,755 is equals to rupees to the river should be paid on or before 15th of December 2025. It is observed that if the same amount is not paid by 15th of December 2024, the rest should be paid full stop. Under such circumstances, till 15th of December, no course of action shall be taken against the petitioner. It is observed that if the amount of rupees so and so, total amount, is not paid on or before 15th of December 2024, the respondents would be at liberty to initiate such action as permissible under law. In the meantime, the respondents are given the liberty, the petitioners are given the liberty to approach the respondent authorities for reconsideration of the schedule of payment if so advised.
One more aspect, they have been defaulting in the current PF also, which they have not paid from the recovery certificate. If that, that should not.
49 is current.
Hmm?
49 is current. That amount of 49 lakhs is the current amount.
Let's see this.
Yes.
Caveat stands discharged.
Obliged, sir.
Supplemented at AP3.
My Lord, the petitioner before Lordship, it's a partnership firm. Lord, that they took part in a tender issued by the Indian Oil Corporation authorities for, my Lord, transportation of LPG cylinder. Now, my Lord, being successful, they were given work order on 25/4/24. Now they are continuing with their contract. Now, my Lord, the show cause notice has been issued, which your lordships will find at page number 227. On 11/11/25. Show cause notice for gross irregularities and fraudulent practice while entering into contract with IOCL tender so and so. We bring to your attention that you have been awarded work order for transportation of Indian LPG cylinder so and so for the period from 1/5/24 to 31/4/29, that is 16 number of packed truck. It has come to our notice that you have falsified details for 16 numbers of trucks registered with your firm and offered in the above cited work order. Issue was taken up with original equipment manufacturer, that is Tata Motors, for verification of chassis numbers being manufactured by them as per RC uploaded in the tender. The OEM by its reply has confirmed that none of the chassis of the trucks bearing registration number so and so, so and so, so and so were manufactured by them as per their internal record. This clearly indicates you have falsified the details of the truck number. So allegation is, my lord, we have offered trucks which are not made by Tata. And in fact, we have given false documents. Now, if your lordship should kindly come to page number 230, my lord.
You have submitted your reply.
No, my lord.
Why?
We say these so-called notices are without jurisdiction. My lord.
Why?
Because, my lord, there is no basis to issue the so-called notice. If your lordship would kindly come to page number 234, my lord.
Yes.
Now, this is the Miller registration certificate of one of the vehicle of this petitioner firm, Louis Transport Corporation. Owner is Sanjeev Chaudhary. Kindly see, my lord, make Tata Motors. My lord, we have purchased second-hand vehicles and we are using it.
Where is the
Similarly,
make?
my lord,
Where is the
your
make?
lordships will kindly come to page number 236.
No, no,
Now,
234, where's the
registered
make?
number AS 25FC4436, owner's name Pradeep Kolita, kindly similar, maker's name Tata Motors Limited. Similarly, if you're Milord, even the this screenshot of the Poribahan is also given, Milord. Similarly, at page number 238, Milord, kindly see AS 13AC 5134, owner is Sanjeev Chaudhary and maker is Tata Motors. So in this way, my lord, all these vehicles are there. Now, my lord, there is a notification by Government of India, which your lordships will get at page number 264. This is a communication issued on 8th of August 2018 by Ministry of Road Transport and Highway to all the principal secretaries of the states and union territories. Please come to me, Lord, accepted subject, acceptance of driving license, registration certificate, or the other documents presented through DigiLocker or M-Poribahan platform. If your lordships would kindly come to clause 5 towards the bottom of the page. In the light of the provisions of the Information Technology Act, it is requested to consider the documents available in electronic form in DigiLocker platform or M-Poribahan mobile app as valid under Motor Vehicles Act and can be treated at par with the certificate issued by the transport authorities. So, my lord, when we purchased the vehicle, we checked up in the M-Poribahan, that shows, my lord, it's a Tata make. And the registering authority has registered it as make being my lord so and so. We do not know on what basis the original equipment manufacturer, that is Tata Motors, has said that. Now what they are intending to cancel the contract and they have issued, and they have already suspended our work and they have issued a new tender also, Miller, at page 230.
What is page 253?
Yeah, Miller. Once. A screenshot of M. Bahan Miller.
When did you take it?
Miller, we have indicated paragraph 10, Miller, we have made the statement.
When did you take it?
Yes. Paragraph 10, Miller, how we came to own these vehicles, we have stated that the petitioner begs to state.
No, Mr. Chaudhary, why I'm saying so?
Yes.
This document could not have been at the time when you purchased it. When did you purchase these vehicles?
It again. Miller, the registration certificates would reveal. Date of registration, 29th of March 2019, 234.
2019. So this document at 253 could not have been there because if it is a pollution control by a vehicle, you require every 6 months or 1 year.
No.
Because it is valid up till 2026.
Page 37, Miller. These are all latest, Miller. This is the screenshot of the M. Poribahan, Miller.
Understood. So this has been taken now.
Now,
It was not valid then. This was not the bad document. You see,
if it is valid now, how it could have been invalid earlier? If it was invalid earlier, how?
No. You see, if your submission is that you had seen the registration certificates and on the basis of that you have taken it. And as such, you did not have the occasion to look into the chassis as to whether it was a Tata make or not. You believed on the basis of that document. So this document at page 237 could not have been one of such document. Because if you have purchased in the year 2019, this document is valid up till 2026.
1 second.
Yes.
Page number.
But you file your reply there. No
No,
case.
Milord, they have issued an NIT. They will not finalize the NIT, Milord. Otherwise, Milord, the entire thing will go, Milord. So Lordship will kindly appreciate, there is no dispute that we have purchased second-hand vehicle. Now, what is the basis, Milord, of they coming to the conclusion that these are not Tata vehicle? Well, then registering authorities also be taken to task. Ministry of, we have made them parties, Milord. Well, we are bona fide businessmen, we have purchased the vehicle. If necessary, we will file an additional affidavit, Milord, where we will indicate when we purchase this vehicle. Now, if your lordship would kindly, now they have issued an at page 230. Milord, this they will not finalize, Milord. On 12/11/25, limited UFR.
But they are asking for 55 trucks. Then how do you know that this has any connection with that?
No, it has, Milord, because
No.
our truck is 16 here and other two.
No, but they have asked you to reply within 15 days.
Yes.
As of now, why will they cancel it?
Milord, we initially we thought of replying, then we came up because we filed this writ petition, Milord. The reason being, Milord, we have purchased the vehicle which has been registered. Is it possible for us to fool the registration department also? Milord, Lordship knows nowadays everything is digitalized. Now, the moment we give a number, it can be correlated with the manufacturer also. All have connections, Milord. In fact, the moment a vehicle leaves the factory, Milord, everything is digitized. Now, where is the scope for on our part to offer a truck which is Tata as a non-Tata or a non-Tata truck as a Tata, unless the registering authority, Milord, side switch us.
But this very submission, you can make it there. Why you are doing it here?
Milord, we have represented before them. In spite of that, they have issued.
No. This so-called notice is there. You submit your reply and I'll go for a hearing.
Now, Milord, will kindly permit me to place one page, Milord. Yes. Now, Milord will kindly come to page number 221. Before issuing the work order, what they did, Milord. Page 221. This was the letter of acceptance. Now, kindly see the last line. Your quoted rate is so-and-so. The list of truck as attached will be utilized against this contract. We would like to advise you to complete the following within 15 days. Then Milord will kindly come to page 222. Placement of truck at Horpara LPG BP for physical verification, along with original documents including affidavit undertaking submitted in the tender as per tender terms. This is what we complied with. Then Milord will kindly come to 223. These are the details of the truck with engine number, chassis number. Then Milord will kindly come to page 224, the work order. After being satisfied about everything. To which so-and-so, this is reference to your participation in the above tender and our letter of acceptance, etc., accepted, duly accepted by you. We are pleased to place this work order on your esteemed firm for packed LPG transportation in vertical position, etc. So, Milord, they have satisfied themselves about everything. Now, based on some report, we do not know at whose instance it was done, Milord, then they could have identified the mischief then.
No, they have, therefore they say out here in the so-called,
No, Milord.
come to a
We
notice
see
that you have falsified
page
to issue was taken up with the OEM for verification of the chassis number being manufactured by them, and they say, and as per the RC uploaded in the tender, OEM has clarified that as per the internal records, nothing is there.
No, Milord, kindly see at page 223, while responding to the letter of acceptance, we have given the details of everything. It's not that we have, now we are saying that, no, this is not our chassis number, it should be different. This is from all throughout, we are maintaining this. Now to take a plea or a stand that this is not Tata make, something more than that has to be there, Miller. And at least in that.
And,
it should
and
be
Mr.
associated.
Chaudhary, you have to also understand, all these trucks are not owned by you
Earlier.
now also. Kindly see the letter of acceptance.
Own. Page 223, all are own.
You see, Louis Transport and Anantos
Partners
Majumdar,
of the
Pradeep
farm.
Kolita and Oy.
These are partners of the farm, 9 partners, huh? We have made a statement, 9 partners of the farm. Page 31, Miller. Kindly see, Miller, 7 partners. Sri Sanjeev Chaudhary, Ajanta Chandra Majumdar, Pradeep Kolita, Govindo Talukdar, Bivarani Talukdar, Noro Kolita, and Pradunna Singha Chaudhary. At least I am entitled to a notice, my lord.
That is the notice given. You
But my lord,
replied,
lord, they have suspended already.
suspension is permissible, isn't it?
No, my lord, suspension in a service.
The
jurisprudence has a different
termination is
definition.
bad. Termination is bad. You go there. I'm here waiting for you for the next round. But I
Suspension
think
in a
your 11 days
serviceman
is
role,
over.
I can understand. But in a Miller contractual, relationship, suspension is a serious step, Miller. End of the day, it is business. We have taken bank loan.
We will take as Mr. Chaudhary, Mr. M.K. Chaudhary's submission that this.
Submission is lordship will examine the matter.
No.
He
I am not.
eventually-
No, Mr. Chaudhary, I will examine after the so-called notice is over. Proceedings. Not now.
Then Miller, at least.
I
lordship-
give you time for filing reply because your period is almost going to be over by within 2 days. Another 7 days time I give you to submit your reply. They will give you a personal hearing and then dispose it.
And Miller, they will provide the communication from the Tata. Number 2.
You have it?
Should be having, Mala, otherwise this notice could not have been issued. For
So it shouldn't be a very long communication.
Yes.
So kindly ask your client to send him a WhatsApp in a scanned document. He'll give it to him during the course. So on the basis, he will submit his reply. And within 7 days, he will submit his reply. And thereupon, you give him a personal hearing. And then you'll decide. And thereafter, liberty given to him to again approach this court.
No, Miller, can I make one submission?
Yes.
Number 1, Miller, the suspension part, they should reconsider.
That is I give you the liberty to request.
Yes.
They may consider
yes,
at
also-
your request. I have nothing to say.
Lordship, observe that, we'll make that clear.
You request, but I am not saying anything that here. But I'll pass the order in your presence only. You see, I am not going to direct consideration also. They can make a request. You may consider. Let me come back at 2. In the meantime, ask him to get that document.
তিনিখনৰ আছে মই বেলেগ বেলেগ মই আপোনাক কৈ দিম গোটেইকেইটা মই মাৰ্ক কৰিছো আপোনাক কৈ দিম My lord, 53, 54, and 55, my lord. 53, 54, and 55, the items, my lord. They're similar items. the issue raised has been similar, my lord. The trucks in item number 53 are mentioned from serial number 35 to 50. I've noted down, my lord. I can.
You are the same council for 53, 54.
My lord. Yes, yes, my lord.
Are these the same dates,
My lord, same this.
so calls?
Yes, 11 November.
So, same order will follow?
Yes, my lord.
No. Heard Mr. Kane Chaudhary, the learned senior counsel, assisted by Mr. R.M. Deka, appearing on behalf of the petitioner. Petitioner or petitioners? Petitioner. Mr. M.K. Chaudhary, the learned senior counsel, assisted by Mr. M. Sharma, appears on behalf of the respondents.
1, 2, 3.
Number 1, 2, and 3.
Madam.
None appears on behalf of the respondent of, full stop. 1, 2, and 3. None appears for, you should have made, most important, you should have made that state transport.
Yes, yes, ma'am.
You have not done that.
Yes, my lord. Yes, I did my lord. When briefing them.
None appears for the respondent, number 4. When the matter is called for. As regards the respondent number 5, did you serve this upon the central government?
Yes, my lord. The name is reflected in the cause list.
None appears for the central government when the matter is called for. So as regards the respondent number 5, comma, this court, taking into account the order which taking into order which this court proposes to pass, dispenses with the notice upon the respondent number 5. Full stop. The petitioner herein is aggrieved by the issuance of a show cause notice dated
11/11. 11/11/2025. 2/27.
11/11/2025 by the Chief General Manager LPG of Indian Oil Corporation Limited. The case of the petitioner herein is that on the basis of a tender for transportation of Indian LPG cylinders in vertical position on unit rate basis, ex Sorpara LPG bottling plant under Indian Oil AOD State Office. The petitioner participated in the said tender process and was issued a letter of acceptance on 6/4/2024. Full stop. The petitioner placed 16 other cases. How many? You give that number, huh?
Yes.
In this case, I'm saying
Yes.
petitioner have placed 16 vehicles and the registration number, the ownership, engine number, and as well as the chassis number were duly mentioned in the letter of acceptance. Full stop. It is the further case of the petitioner that in the registration certificates which have been issued to the petitioner, it has been categorically mentioned that the vehicles in question are are Tata Motors make. The vehicles in question, the maker of the vehicles in question to be Tata Motors Limited. Full stop. Be that as it may, a show cause notice have been issued on the basis of a communication issued by the impugned show cause notice was issued dated 11/11/2025 based on a communication issued by Tata Motors Limited, whereby it has been informed that the manufacturer, that they are not the manufacturers of the engines or of the chassis in respect to the vehicles provided by the petitioner. And as such, it has been alleged that the petitioners have violated tender clause number 1.15 under chapter 7 and the petitioner therefore were asked to show cause as to why action should not be taken against the petitioner for violation of the terms and conditions of the tender. It is further seen that the petitioner were also granted time to submit the reply to the show cause on or before 26/11/2025. Mr. Kane Chaudhary, the learned senior counsel appearing on behalf of the petitioner, submitted that taking into account the materials on record, more particularly the registration certificate, as well as the certificates issued by the M Parivahan website, the question of issuance of the show cause proceedings is nothing but an abuse of the process. And as such, the impugned show cause notice is required to be interfered with. Per contra, Mr. M.K. Chaudhary, the learned counsel appearing on behalf of the petitioner, the respondents, submitted that the show cause notice have been issued to ascertain certain facts. And these facts, the petitioner ought to therefore reply and place such materials before the respondent authorities. Mr. M.K. Chaudhary further submitted that it is a straight principle of law that a court, while exercising the jurisdiction under Article 2 to 6 of the Constitution, ought not to entertain such writ petition challenging the show cause proceedings, more so in a case of a present kind where certain facts are required to be asserted before any decision is taken. The learned senior counsel for the respondent further submitted that in the instant case, no decision has yet been taken, and it shall be only taken after the petitioner herein avails the opportunity of submitting the reply. After taking into account shall be taken only after taking into account the materials available with the respondents, and if the petitioner submits the reply with proper justification, the same shall be duly considered. This court, having heard the learned counsels appearing on behalf of the parties and having also perused the materials on record, is of the opinion that the show cause notice which have been issued upon the petitioner is giving the petitioner an opportunity to explain as to whether there is any violation to the terms and conditions of the tender. It is the opinion of this court that such factual adjudication can only be decided by the respondent authority, decided by, it is the opinion of this court that without any factual adjudication being done, comma, it would not be proper on the part of this court at this stage to interfere with the said show cause proceedings. This court further takes note of the submission made by Mr. K. N. Chaudhary, the learned senior counsel, who submits that though the notice show cause notice have been issued based upon a communication issued by the Tata Motors Limited, comma, however, the said communication have not been provided to the petitioner, and as such, the petitioner would not have a reasonable opportunity to submit the reply. Full stop. Taking into Mr. M. Sharma, the learned counsel appearing on behalf of the respondents, number 2 to 6, during the course of the hearing, provided
1 to 3.
1 to 3. During the course of the hearing, provided the copy of the communication dated 11/8/2025
My lord.
issued by the Tata Motors Limited
My lord.
to Mr. R.M. Dekar, the learned counsel, appearing on behalf of the petitioner. So, taking into account the above, the writ petition therefore stands disposed of with the following observations and directions. First, the petitioner hearing is given the liberty to submit reply to the show cause notice dated 11/11/2025 within 10 days. 10 days from the date of the present order, that is on or before 8th of December 2025. Full stop. Next. The respondent authorities, upon receipt of the, if any show cause reply is submitted within the period as above mentioned, comma, shall afford the petitioner an opportunity of hearing. And thereupon pass appropriate directions and thereupon shall decide the said show cause proceedings in accordance with law. Number 3. Though Mr. K. Chaudhary, the learned senior counsel, submitted that during this period, when the show cause proceedings are being initiated, are undertaken, the suspension which have been put upon the petitioner by the impugned show cause notice dated 11/11/2025 requires to be stayed. Full stop. It is the opinion of this court that any such stay would not be in the interest of justice. However, and in any such, this court is not inclined to pass any such orders. However, liberty is given to the petitioners to request the respondent authorities, more particularly the respondent numbers 1, 2, and 3, seeking suspension, seeking stay or suspension of, seeking stay of the suspension order, and the respondent authorities would further be at liberty to consider the same in accordance with law. Anything more?
We'll submit
The-
before 8th,
Huh?
Before 8th of December, we'll submit it.
Yes.
And the time frame kindly be fixed, my lord, for the decision, my lord. After 8th, my lord.
They are doing it.
You will be doing it at
Because
the
our
earliest.
books are under suspension, my lord.
It will depend on personal hearing. Tomorrow, if I fix a time, you will be in difficulty. I would have otherwise fixed the time. but you will be in difficulty. They will do it.
We'll do it, my lord.
They will do it because they are also business. Because tomorrow if they lose it, yeah. So that last thing, liberty given to the petitioner to approach this court in the circumstance. Any decision is there an appeal provision against that so-called proceeding?
My lord, as far as I'm aware, my lord, on the basis of the information, no, my lord. As in the reply has to be given
As per
first.
the condition, there is no such provision, my
There's
lord.
no-
Liberty given to the petitioner if there is no appellate provision to approach this court in the circumstance the so-called proceedings are decided against the petitioner.
Deeply obliged.
54.
In case the so-called proceedings are decided against the petitioner or within a reasonable time the so-called proceedings are not decided. Isn't it? I gave both.
Yes.
For in case the so-called proceedings is decided against or within a reasonable time the so-called proceedings are not decided.
Yes, deeply obliged.
Production list item 1.
That doesn't mean that you come immediately.
Deeply obliged.
We go as per the governor's order, reasonable time.
Respect again, detector gates on the lordship has passed judgment. While setting aside the short tender notice, granted liberty to the authorities to give the settlement to the bidders. But they have issued another short sale notice. 1 month period.
Huh?
1 month, lordship will kindly see your lordship judgment at page 36. And relevant is at page 40.
41,
440.
40.
Yes. Accordingly, the instant disposition therefore.
Given the liberty to grant the settlement for the remaining period up to a month to the eligible in
Yes.
accordance with law.
In accordance with law. Now they have issued another short tender notice. Page 41.
So they want to go for a tender now.
Hello?
What
No,
is
for
wrong?
1 month, for 1 month.
Let them go. Why should I stay it?
Unless your lordship judgment is there.
I gave liberty.
No, your lordship has given liberty.
I am not saying that it should be settled with you.
Not to me, well, for the bidders.
I only set aside the retender notice on the ground on which they have taken. Are given the liberty to grant the settlement for the remaining period so and so to eligible in accordance with law.
To the
So
bidders.
now they
the
are
eligible
at
bidders.
liberty to do it. Either granted they or may not go for, they may like to go for a short tender.
Your lordship has directed that, otherwise, my lord, your lordship will kindly see the first tender they have issued. The settlement was given at an amount of rupees 1 crore without tender. Then I participated, and that my bid was there. So they.
Mr. Bididas, I think you should come after that 1 month is over. Let's see for the next 1 year, how do they do it?
Well, this bidder, this petitioner may not get any relief, I understand that, my lord. But since your lordship has disposed of the matter, you select.
I've
one of the
never,
bidders.
I have UA number 4 or something, na?
Yes.
UA number 4 in that earlier bid.
Your lordship has quoted that page 36.
Yes, you quoted something. Your name was some Mohit Huzal, na?
43 lakh.
Mohit Chansara. UA number 4.
Yes. 1
Yes.
crore
So
43
instead
lakh.
of that, now they want to give it to this.
No, now they, my lord, they are, for even for that period, my lord, for another 1 month, they are giving short, so they are issuing short tender. Even for 1 month, my lord, they should select from the bidders. Earlier short tender notice was dismissed by, set aside by this court.
Kindly see what is this number 4th line. The tender amount is calculated on the basis of assessment report for the period of 30 days with effect from 1610 to 1412. What is the?
Lordship, in that period, the department was running the gate. So on
You are yet to run till 1412.
Lordship, 1610 or a second, from. 10 to 14/11.
How is it possible? Your tender is defective. Don't you think so?
Lordship, after the.
You are fixing a rate on the basis of something which is yet to happen. Because you see, you are at a nick of time. You want to give it from 1/12 to 31/12,
31/12, Lordship.
1 month.
Lordship,
But you are going to calculate the tender amount
Lordship.
from 16/10 to 14/12. How is it possible?
Lordship, during that period, whatever the department has collected through the.
How will you collect from till 14/12? You are going to give it from 1/12.
No, tax for the same. Was called to as actual cancellation.
Isn't it defective?
Lordship, whatever we have collected in that period, 16/10 to. 10
Again, I'm telling you, how can you collect 1/12? You are to submit this bid. Last date of submission of the bid is when?
26th,
26/11.
26/11,
Okay.
Lordship,
You have to give before 1/12, isn't it?
Lordship.
But you are going to calculate on the basis of some thing which will be from 16/10 to 14/12. How is it possible?
16/10 to 14/11, Lordship.
It is 12 here. You cannot come up and say 11.
Lordship, with effect from 16/10/25 to 14/11/25.
Where is 14/11? You can read 11 in 12. Is it possible for me to read? I'll go as per this only. But how can you read 11? Huh? How is it possible?
Provision for tax. This is the
Instead
report.
of why were you not looking into it?
Lordship, this is the report collected.
You run it for 1 month
Lordship,
and then go for this, whatever. But why are you doing for 1 month?
Lordship, as the.
Or give it at him, you are fully putting the tender value at rupees 7,30,000. Because this cannot happen unless you come up with a corrigendum that it should be taken from 14/11.
Lordship, this is just the assessment made by the inspector of.
Unless you come up with 14/11, as of now the tender notice is wrong. Don't you think so? Huh?
Lordship. Lordship. But
What?
as per the clause 7 of the NIT only, we are going for the retender, Lordship. And after passing of the judgment by this honorable court, we have settled with the highest bidder, and the highest bidder has surrendered. As of the same, we have gone as per the clause 7 of the previous NIT tender. We have gone for the fresh retender, Lordship.
So you gave it to the highest bidder
Highest bidder we have approached already, and he has surrendered.
and he has surrendered.
So
So
it's
now therefore you have gone for a new one.
new one.
Very well. But isn't this wrong? Huh? Can you settle this?
So as per inspector, report of the inspector X, now we are getting.
You do one
friends
thing.
amount. Lordship.
You do one thing. I have this matter on Wednesday. Come up with a corrigendum. Can you? Otherwise, I'll have to stay this. If I stay it, then you cannot do it.
This petitioner, earlier he came, the lordship has set aside that short tender note. There, purposely they are saying that we are not going to give it to him. Something is there with the present petition.
But for coming for 1 month also,
No,
this is wrong. No, but Mr. Das, this is wrong. But the fact that if it is wrong also, your tender notice is wrong.
And on
The
Wednesday,
tender amount is calculated on the basis of assessment report for the period of 30 days with effect from 16/10 to 14/12.
30 days.
It should be 14/11.
16/10 to 14/11/25, Lordship. With effect from 16/10/25 to 14/11/2025, Lordship.
It is subsequently given. the provision assessment of tax of the month for a month with effect from 14/10 to 14/11. This is given,
Yes.
was called to ascertain the actual year. The assessment indicated an average calculation of the year was compared with the second highest bidder quoted rate. A substantial gap was observed. Therefore, after careful examination of the revenue assessment under so-and-so, authority deemed it within the area to offer retendering as so-and-so. All interested bidders are here. Chalo. We take it as 14/11 then.
Lordship.
So,
And Lordship, we have received instruction, Lordship, may I place the instruction?
what is your instruction?
Instruction is regard the assessment and all, Lordship. That's the exact figure
Ah.
of the collection when
You
done
got
by
it?
the authority.
How much?
9,14,880.
9?
9,14,000 in a month, Lordship.
Oh.
So that's why we have given the tender for 7,30,000, Lordship.
So you,
Considering
for
all those
that
assessment-
period, you got 9 lakhs.
9 lakhs only, Lordship. That's why only we have gone for retender, giving the
So,
tender value
no,
of 7
submit-
lakhs.
Submit your bid.
Your lordship knows if he speaks on 27, there, my lord, they have given it to person who got it at 5 crore. That was, that he could not fulfill, so therefore they have set aside. There also the petitioner said, my lord, the next persons who are in the line, they
But
should-
Mr. Das, that day also I said to you, I cannot give bid to you. I only gave them the liberty. So they gave it to the highest bidder did not opt for it. So now they thought of going for a cancellation. Now with the cancellation, now they want to do it. They don't want to go to, you are number 4.
And if to settle,
cancellation, they will not take it because the initial tender was. for
I think
particular
this is not a
particular
case for
circumstances.
stay. Okay, you want to, I can issue a notice only, no stay. You want a notice?
The petitioner who is in the line, my lord, and the other persons who are not accepting it because the period is not there. Their tender value was. for the
But by
period of-
filing the writ petition, you got one figure. That amount you got it, na?
No, I didn't, that 9 lakhs. Yes, 9 lakh, 9 lakhs will not help me out. Because I have quoted 1 crore 43 lakhs, that will come to about 14 lakhs. That will come to about, if we divide by that period.
12 lakhs.
It will be more than that,
The 12 lakhs.
yes.
Less than 12 lakhs.
Yes.
Because if it is 12 months, it is 1 crore 44.
It was 10 months.
if we settle, Lordship, with the petitioner,
more
they
than
will
that.
incur heavy loss, Lordship.
Huh?
They will incur heavy loss if we settled with the petitioners, Lordship. They will incur, we are not going to incur, Lordship. As the assessment itself is very much clear, Lordship. That we are getting 9 lakhs in a month only. in a-
They are going to give you 12 lakhs. Is the petitioner not giving you 12 lakhs? Then
But in public.
I
interest,
don't
Lordship,
understand what is wrong with your people. You were getting, last time you got 70 lakhs
Lordship.
for the entire period, which otherwise you could have got from the petitioner 1.4 or from the number 1 bidder 2.82. You did not settle it, but you wanted to go for them for retender.
We can-
Something is wrong with your people. Dima Hasao. That executive, some person.
They're acting arbitrarily, my lord. Your
Huh?
possible can is a first settlement
Lordship.
order, they have given it without tender. That page 19.
And Lordship, the second highest bidder is not the petitioner, Lordship. Petitioner is not the second highest bidder. If to
Petitioner is not the second,
Fourth.
the petitioner is not the third.
not a-
Petitioner is the fourth.
First, second.
So they have
third,
no
are
individual
accepting
right,
it
Lordship.
Because, my lord, they quoted the price for that period. So in that line, I also suggested my client.
You were that. Anyways, okay, we'll issue notice, no notice. We dismiss it. Heard Mr. B.D. Das, the senior
That
counsel
will-
assistant. Huh?
Your lordship dismiss it, then it's better I withdraw it, my lord.
You withdraw it.
Actually not.
You withdraw it, you participate, and then you again come back.
Because they have quoted 9 lakhs,
Now you got that amount, na?
but I am quoting, they are getting more than me.
That is okay, but this is, for this court to look into it, this is very difficult.
But your lordship in the other round of case, your lordship has. given
Anyways,
pick up from
you see,
petitioner.
Mr. Das, there should not be any dissatisfaction, so I should give reasons for dismissal. Okay, heard Mr. B.T. Das, the learned senior counsel, assisted by so-and-so appearing on behalf of the petitioner. Mr.
D. Thousand Lordship,
So-and-so appears on behalf of the
NC Hills,
respondent,
all the respondents.
all the respondents. Full stop. The petitioner herein has filed the instant writ petition challenging the short tender notice dated 19/11/2025, whereby the Chief Executive, Secretary Executive Committee, NC Hills Autonomous Council have issued a notice inviting tender for settlement of the Ditokchera vehicle gate for the period from 1/12/2025 to 31/12/2025 at the official value of rupees 7,30,000. Full stop. Mr. So-and-so, the learned counsel appearing on behalf of the respondent submits that the tender amount so calculated is to be calculated on the basis of the assessment report for the period from 30 days, that is with effect from 16/10/2025 to 14/11/2025. Full stop. The grievance of the petitioner herein is that the respondent authorities, for reasons best known, have not granted the contract to the petitioner for running the remaining period from 1/12/2025 to 31/12/2025, in spite of the order passed by this court dated 24/10/2025 in WPC number 2320/2025. The learned senior counsel submits that the retender notice dated 22/4/2025 was set aside by this court, and liberty was granted to the petitioner, to the respondents, to settle the remaining period up till 31/12/2025 to the eligible bidders in accordance with law. The learned senior counsel submits that instead of doing so, the respondent authorities have gone for a short tender notice for the period from 1/12/2025 to 31/12/2025, and thereby, which is nothing but a colorable exercise of power. Full stop. Mr. So-and-so, appearing on behalf of the respondent, submits that in pursuance to the order passed by this court dated 24/10/2025 in WPC number 2320/2025, the respondent authorities have tried to settle for the remaining period with the highest bidder, namely
Dr. Hozai.
Sri Siddharth Hojai, who had quoted rupees 2,87,50,200 for the entire period from Six 5/2025 period from
Page 34, Lordship.
Huh?
Page 34.
From 1/3, na?
12,
Earlier tender?
12/4/25 to 31/12/25. Page 24, Lordship.
No, earlier tender was from 12/4/2025 to 31/12/2025. However, the said bidder did not accept, and under such circumstances, a decision was taken for retendering. The learned counsel further submitted that liberty was given to by this court by the order dated 24/10/2025 to grant the settlement for the remaining period up to 31/12/2025 to the eligible bidders in accordance with law. And under such circumstances, it was duly offered to the highest bidder. But as the highest bidder had refused, the respondent authorities, therefore, in the interest of for public interest, have issued the short tender notice Full stop. This court have duly heard the learned counsels appearing on behalf of, in addition to that, the learned counsel further submits that for the period from 16/10/2025 to 14/11/2025, the amount which was calculated on the basis of the assessment report was rupees
9,14,880.
This court duly heard the learned counsels appearing on behalf of the parties and have given an anxious consideration to their respective submissions. Full stop. It is relevant to take note of that this court, by an order dated 24/10/2025 in WPC number 2320/2025, disposed of the writ petition with the following observations, which is at paragraph number 13 of the said order, which is reproduced here in under page 40. From a perusal of the above quoted portion of the order, it would be seen that this court not only set aside the cancellation of the tender process by the order dated, and not only set aside the cancellation of the tender process, but also the retender notice dated 22/4/2025. However, this court granted liberty to the respondents to grant the settlement for the remaining period up to 31/12/2025 to the eligible bidders in accordance with law. Full stop. Mr. D. Towson, appearing on behalf of the respondent, respondent counsel, had duly submitted that the respondent counsel had offered it to the highest bidder, and the highest bidder having refused, in the public interest, a short tender notice have been issued. Considering the above, it is the opinion of this court that the issuance of the short tender notice, thereby trying to settle for the period from 1/12/2025 to 31/12/2025 by a tender process, cannot be questioned in the present facts of the case. Accordingly, this court does not find any merit in the instant writ petition. The writ petition accordingly stands dismissed.
Deeply obliged.
For admission, item 10.
Voluntary Association for Social Upliftment.
I have appointment at 3:32.
Huh?
Before the doctor matter anyway, I'll do this matter and go.
You have been?
I've got appointment with the doctor at 3:30, my lord. So, my lord, here, my lord, whatever this association, my lord, this NGO was doing work with the Assam, AIDS Control Society under the NACO. And since 2003, and there was no any bad record or any blemish. Ultimately, last agreement they executed was from 1.
Mr. Nayak, what is your stand?
My stand is that our agreement with the party was till March 2013, Lordship. And till that period, whatever is due to them, that has already been paid. Thereafter, Lordship, the contract was never renewed. So nothing is payable from our side, Lordship, thereafter, March 2013.
And he is asking for a period from?
Beyond March 2000.
April to September.
So your agreement was up till that. Can you show me that paragraph?
If Lordship comes to paragraph.
In the agreement is annexed.
Yeah.
Paragraph
What is
5,
for
Lordship.
paragraph 5?
Page 100, Lordship.
Had the contract for the targeted intervention were with the petitioner till Iman. During the agreement was so and so that the agreement shall remain in force from Iman to Iman, unless terminated earlier in accordance with or in the event extended through mutually agreed agreement. Is there any agreement that pursuant thereto?
Thereafter, whatever you also kindly come to annexure 1 of the repetition. The agreement expired rather on 31/3/2020, 13. Thereafter, annexure 1, page 17. If the agreement had expired, no doubt, but they continued with me and took my work till September end. And that's why
It is written to whom?
it is written to all the NGOs those who are working under
Your
them.
name is not replaced.
Yes, my lord, you will also will find my name in page number.
It repairs to so and so,
Page
so
number
and
20.
conducting a one-day Iman on so and so in
Completing a
3
training.
batches and so you are requested
They're
to
working
depute
and
your
they're
project
carrying
manager
out.
to attend. So where is your agreement?
There is no action taken, but they continue to take the my service. There also any come to page
That
20.
civil court. I can't look into this. Okay. Isn't it, Mr. Nayak? Civil court?
That is the only option.
No, my lord, it is
Okay, your doctor's appointment is at what time? Your doctor's appointment?
3:30.
Huh?
3:30.
Okay, 5 minutes. We dismiss your petition. Wait. Heard Mr. R.P. Sharma, the learned senior. No, don't spoil your time.
No, I'm not spelling my name. I'm not spelling.
No, I'm on my time. I'm there. We finish it here.
Otherwise,
No case.
Train us after the expiry of the agreement.
Heard Mr. R.P. Sharma, the learned senior counsel, assisted by so and so, appearing on behalf of the petitioner. Mr. P. Nayak appears on behalf of the
I'm appearing for the
respondent numbers 1, 2, all. You can appear for all.
only for state age control. system.
Huh?
No.
1 to 6
He will appear to respond to 3, I think.
appears
I'm
for 1 to
appearing for
6.
3 only, Lords.
Huh?
Three.
No, you can appear for all.
I can appear, but they are appearing, Lords.
No, they are not appearing anywhere. They don't know. 1 to 6. If family health, they cannot appear. They can't appear for health.
No,
You are to appear for health.
D. Bora is there.
No, nobody is here.
Lots.
1 to 6. Now, the petitioner herein has approached this court seeking a direction for payment of the outstanding amount of rupees 7,64,676 due and payable to the petitioner for the work executed by it in terms with inverted comma targeted intervention project for injecting drug user bracket TIP for IDU bracket close under project ID number IDU03 inverted comma close allotted by the respondent number 3 during the financial year 2013-14 along with interest at the rate of 18% per annum for the delay caused in making the payment making the payment. Full stop. The respondents have filed the affidavit. Respondent number 3 has filed an affidavit wherein at paragraph number 5, it has been categorically mentioned that the petitioner was granted a contract for targeted intervention project till March 2013. Full stop. It is further mentioned that during the agreement, full stop, duration of the agreement was clearly stated in the agreement copy and the performance bond executed with the petitioner that, inverted comma, the agreement shall remain in force from 1/10/2012 till 31/3/2013, comma, unless terminated earlier in accordance with the provisions of the this agreement, or in the event the period is extended through mutually agreed amendment to this agreement, inverted comma, close. Full stop. It is further mentioned in the said paragraph that there was no question of further claim by the petitioner for the next financial year, that is from 2013 to 14, as state AIDS controls had no contract grant agreement with the grantee. Full stop. Mr. R.P. Sharma, the learned counsel appearing on behalf of the petitioners, however, submitted that though there was no agreement entered into by and between, no written agreement entered into by and between the parties, however, the petitioners were asked to depute their project managers to attend a training program, and thereupon the petitioners' services were taken, and as such, the petitioners were entitled to the said amount. It is the opinion of this court that as there was no agreement, written agreement entered into by and between the petitioner as well as the respondent for the period from 2013 to 2014. And further, the respondents had categorically denied of having entered into any agreement. It would not be proper on the part of this court to enter into the arena of disputed questions of facts as to whether there was any agreement and further as to whether the petitioner performed such work. Full stop. Under such circumstances, this court is not inclined to entertain the instant writ petition, and accordingly, the writ petition stands closed. Full stop. Liberty, however, is being given to the petitioner to approach the competent civil court or the competent court of civil jurisdiction. In the circumstance, the petitioner is approach the competent court of civil jurisdiction, and taking into account that the petitioner have been diligently and bona fidely pursuing the present proceedings, the period from 25/6/2018 till date be excluded while computing the period of limitation.
13. My lord, yeah, one more prayer, my lord. No, I took 24 minutes today.
Huh?
I took 24 minutes we take today.
Why? We still have time. Let us take up 24 also. Wait. We finish it. Humanity. 24 to do. Wait, 24 we take it.
I'm also to get the instruction whether he has shifted it or whether he.
24 will let us finish it or wait. Don't worry. 24. What is this?
It was a, I had one. I was running a mallet, stone crushing mill. Now, since long back, then 2022 notification came from government of India. And
Who is paying for forest?
what is the?
Affidavit filed.
We have filed the affidavit, my lord. There, my lord, because ex officio chairman, my lord, district commissioner, but the.
Respondent number 5 has filed the affidavit.
Forest. Report of divisional forest officer, my lord, we have annexed as annexure 4, my lord.
Well, I'm going to get the instruction whether he has shifted or he cutting there or a made automation. So let it take 1st of December, my lord. I'll get the instruction.
You want to file a reply?
Yes. I'll file on the point one whether if it's other shifted, then this becomes infructuous. That is the
But in view of the recent judgment passed by the Supreme Court,
Yes.
your case has already gone for a 6. It is today, before going to the doctor, I don't want to dismiss one more. So, we'll have it in it. Mr. R.P. Sharma, the learned counsel, senior counsel, appearing on behalf of the petitioner, submits the petitioner would like to file a reply to the affidavit in opposition filed by the respondent number 5. Lists the matter after the affidavit in reply is filed by the petitioner.
Item 13.
Yes.
My lord, I pray that this matter may be taken up some other day.
Why?
I need some instruction from the petitioner. I need to file my Bakaladma as well, my lord.
What?
Bakaladma as well, my lord.
Why?
My name is not in the.
What is the matter about?
My lord, here, but petitioner license was
By which the on license given to her was suspended. This court in time had stayed the impugned suspension order. The petitioner in the meantime has filed an application to the Iman for permission to shift the Iman to location near. Concerning the need of the liberty to consider the representation submitted by so submitted which identify the area where it is.
Yes.
How can there be a suspension of a suspension order?
Yes.
Give me a good idea. How is it possible? How can there be a suspension of a suspension order?
During the pendency, I have filed an application to transfer my particular
License.
shop to another place. However, till now there is no outcome. And subsequently, I have filed an application before the.
Are you still running that
My lord,
particular,
Yes,
where's the order you are challenging?
Page
Huh?
74,
Page?
page 74, annexure 23.
What is the ground?
Lordship, he has altered the entrance route of the IMFL sub lordship.
Huh?
He has altered the approach route of the IMFL on sub lordship. He's reduced the length from the national highway. Initially, it was 223 meter. After that, it is reduced to 31 meter lordship.
I have applied my license on shop license in the urban area.
On or off?
On.
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 You are having a bar
Yes, yes,
on top of the highway.
yes.
My goodness. Where is that? Where is it?
It is Saridwar Revenue Circle.
Huh?
That's for district.
My goodness. National highway. Even after the national highway bifurcated, then also you are having it on the national highway.
I was granted license on the, after verification of all my documents,
Hmm.
after verification, and all the, like, I have been certified that like the particular area is a.
But
urban
is
area.
he still running the bar?
Here. I mean, 3 moderator.
How can you run the bar? There can be a suspension.
Suspension order has been stayed by this honorable court.
So I therefore vacate the stay. Yes, you cannot run.
During the pendency, my lord, I have also filed an application before the district.
So therefore, by filing that representation, you admit.
Yes.
Madam, are you not admitting by filing the representation that you want to shift?
No, my lord, not in that way, my lord. And during emergency, my lord, I also filed an application before the district commissioner to convert my online on.
Okay, we do one thing. No, this has to finish. Today I am giving you, you prepare it properly. Next Thursday, 2 o'clock, it has to come to an end. No more running a bar without the. Okay.
Lordship, Friday next Friday.
Oh, then I grant you.
No.
No,
I'll-
don't worry.
I'll-
Okay. Ms. So-and-so appearing on behalf of the petitioner submits that on one hand, the petitioner had submitted a representation to the respondents. However, the representation have not been taken into consideration, had not been disposed of. Okay, list the matter. Mr. N. Goswami shall, learned counsel for the respondent, Excise Department shall apprise this court as regards as to whether, apprise this court as to what steps have been taken for disposal of the representation of the petitioner. Full stop. List the matter after 6 weeks. Interim order passed earlier shall continue till the disposal of the petition.
Okay.
Okay. One day, because of one day, what happened to your excise department? Till the next day, the data could go 6.
But Lordship, may kindly peruse the last order, 2210. ये कागज लो। ये photo दीजिए।
Oh, yes, did you do it?
Yes, I have received the instructions.
Reference today, you are hereby informed that 2 species of Iman are allotted at the first floor building. In this regard, you are instructed. So done.
Lordship,
Nothing remains. Go. Finished.
In the first.
letter, nothing was today by.
You
No,
got
no,
it.
they have-
This
they
is
have
how
not-
you
they-
get
they
things
have not
out here.
contacted,
Na?
my lord. My instruction is there.
One thing is that, Lordship, in the first floor, Lordship, some outsider Lordships are given, I have stated, Lordship. I may be given the liberty to implead them as a party in the main deed petition, Lordship. Because first floor, Lordship, there was an agreement, Lordship, that.
You are given on the first floor.
Yes, my lord. In the,
sorry,
in the
on
first.
Ground floor, Lordship.
No, ground floor is finished. You have not made the party. We are not going to allow you after 3 years. Take this, be happy. Getting it on the first floor, only problem is that there were 47 rooms on the ground floor. As per his instruction, there are 47 rooms which have already been allotted to various vita holders like the petitioner. However, on the first, there are no specific rooms, but specific portions are allotted to various. So and so here, taking into account, they are directed to take effect for issuance of allotment orders to the viewer for specific areas on the first floor.
Lordship,
it
they
is
have,
being given.
Just now, my learned friend has given
Yes,
Lordship.
yes.
Let me take some instruction on
This
that,
was,
Lordship.
this was on 21/11 and malab the petitioners, they could not be contacted. In fact,
Why?
in fact,
They
in
are
fact-
the Lordship, I pray Lordship, only 3 days Lordship, at least I will communicate their.
Okay, please communicate.
Lordship.
Mr.
But-
Dinath, appearing on behalf of the
Because
respondent.
no letter was communicated to us.
Respondent
This morning
submits
I
that in pursuance to the order passed by this court on 22/10/2025,
Lordship.
both the petitioners have been informed that two numbers of spaces, that is space at serial number 50 and space adjacent to serial number 50 has been allotted in the first floor of the business center Lonka
Lordship.
to the petitioners. The petitioners have also been instructed to deposit the security deposit money bearing an amount of rupees 50,000 respectively at the office of the undersigned within 30th of November 2025. Mr. K. A. Mojumdar, learned counsel, if the said document is stopped on record and marked with the letter Y. Mr. K. A. Mojumdar, the learned counsel, appearing on behalf of the petitioner, submits that to his instructions, the petitioners have not yet been intimated about this order. Be that as it may, he submits that some time may be granted so that he can intimate his clients about this order. So list this matter again on 28th of November 2025 for an update.
I have given a copy, madam. I have already served a copy. Of 16.
What is this, madam?
Non-payment of higher wages of the day.
Non-payment of contractual dues. Police,
Yes, Lordship, we have.
what is
filed
your
our-
instruction?
Yes, we have filed our affidavit, Lordship. They have claimed some excess amount.
Huh?
Page 65, they have claimed some excess amount.
So paragraph 506,
Yes, Lordship.
paragraph 5, police or case, 5 and 6, disposed of 6 months. DGP.
All respondents.
17.
Where? What is this?
Lordship,
What happened in pursuance to the inquiry report?
Lordship, one communication has been communicated to us, Lordship, that because of the newly appointed this officials, Lordship, they want some time to furnish. This is the instruction, Lordship, we have received on 21/11.
What happened? Have you looked into my order dated 17/11/2025?
Lordship, matter may be possible for time being, Lordship.
Ah. You file your affidavit. Why you are not filing the affidavit?
Lordship, one
Already
ins-
signed it. I have filed.
No. Pursuant to the orders passed by this court?
Lordship, one instruction has been received by us.
Instruction
Lordship,
business.
Because the process is going on, Lordship.
I am
per
asking
on the
you,
court's order,
you see, you have what further actions have been taken in furtherance to the inquiry report dated 26/2/2025. Annexes Annexure 1 to the additional affidavit in opposition filed by respond number 2 to 6. What steps have you taken? Sure. We ask the principal secretary to be
No,
present.
Lordship, Lordship,
No.
Kindly,
No, nothing doing.
Lordship,
This
can
seems to be-
10 minutes.
No.
Lordship.
It is seen that in spite of opportunities being granted, the None has a,
Lordship,
the instructions which have been sought for by this court on 22/10/2025 have not been replied to. Considering the above,
Lordship,
let the
Kind request,
Director,
Lordship,
PNRD Department, BTC, Kokrajhar, be present to on 1st of December 2025 at 10:30 a.m. so that he is in a position to, so that the inquiries which have been directed, the queries which have been made by this court on 22/10/2025 can be answered. Full stop. Miss N, what is your name?
Lordship, kindly, Lordship.
What is your name?
N. Chaudhary.
So and so shall provide the video conferencing link at 10:30 a.m.
Non-criminal contextual field matter.
Period.
Page 16, my lord, the exceptional chief engineer has requested the additional principal secretary in the council, my lord. Regarding the fund, my lord, for release of the petition to the petitioner, my lord. And completion report, your lordship will find at page 16, my lord.
How much amount?
19,93,423. Lordship will find at page 16, my lord.
Thompson to verification, then pay by Thompson.
My lord.
Verification 1 month, and BTC out.
In 20.
Lordship, in this matter,
Madam, in your other matter, those matter,
yes,
I gave you 14 days, I'm making it 30 days. Because the order has not been uploaded. It was a very long order, some correction.
I can understand.
Yes, so, then that's around 60 pages, so therefore.
60
some
pages.
Huh? Yeah,
60
because there are 2 days, na, I dictated.
Absolutely.
So, around 60 pages, so you'll get it tomorrow you'll get it. So therefore I make it 30 days.
Right.
Because I gave you 14 days, na, otherwise they will take that as an objection. Give you 30 days.
Obliged, Lordship. Lordship, in this matter, they have filed the affidavit in reply. We got the copy just now. And in item number 20, the deputy commissioner, as well as the labor commissioner has filed 19, those copies have not been served on us. 19 itself.
19 you are the petitioner, 19 you are the,
I am the respondent.
what is the matter about?
Lordship, we are challenging the order passed by the Assistant Labor Commissioner under section 15(3) of the Payment of Wages Act. In the sense that that order is not legally tenable. For 2 counts, one, what he did, the Assistant Labor Commissioner, he himself filed an application under section 15(2) for implementation of a conciliation order, and he himself even filed an application for condonation. He decided the matter himself. That apart from being bad, even as per law, that order is not tenable. In as much as they have given fantastic amount of penalty, which is not envisaged by law.
And what are you challenging?
My lord, I am not challenging any order, my lord. My case is that I was working as a security guard in the erstwhile Dhubri Matchbox company, my lord. Now, my lord, in 2013, this particular Matchbox company was overtaken by ITC. Now, my role as a security guard continued. Now, my lord, in 2015, when they discontinued my salary, wages, then I filed a complaint before the Assistant Labor Commissioner. My lord, Assistant Labor Commissioner initiated a proceeding under the Industrial Dispute Act. Now, my lord, when the proceeding was going on, under Section 11, there is a conciliation process which is which can be envisaged and which can be taken up under the Industrial Disputes Act. Now, conciliation happens. Now, in the conciliation, both the parties agreed, and my lord will kindly see the conciliation proceeding at page 32.
How much is your amount?
My lord, in the conciliation proceeding, it was stated that the amount arrear salary from the month of from 1/1/2016 up to 17/3/2017, 1,04,822. Now, my lord, it was agreed by both the parties, but their case was that we have retrenched you. That is why you are not entitled for any salary. Now, their contention, my lord.
But why you asking for some 82 lakhs?
Now, that after this conciliation proceeding was done, my lord, the amount which was determined in this conciliation proceeding, it was stated that they will pay me within a period of 1 month and a check in the form of a check. Now, my lord, when they pay me that particular amount, they pay the amount of 1 lakh plus another 1 lakh in a form of retrenchment compensation. Now, my lord, in that particular order, they say that you have been retrenched, so please take this conciliation amount and also the retrenchment. I say that I am not going to accept the retrenchment amount because as per Section 25F of the Industrial Dispute Act, you have to give me a 1 month notice before retrenching me. So I decided I will not take the amount. Now, my lord, after they insisted that you have to take this amount, but I did not accept it. Then I filed a complaint I filed a second complaint before the Assistant Labor Commissioner. Now, my lord, now that complaint was decided in the year 2022. So my retrenchment in the conciliation proceeding, it is stated that no, that retrenchment prayer which ITC has stated is rejected. So my arrear salary continues to be accrued. Now, in the year 2022, when it was decided, now my arrear salary becomes 8,12,000, 8,18,000 something. Now, there is a penal provision in the Payment of Wages Act that up to 10%, up to 10 times it can be penalized. So that 10%, 8 lakhs into 10, it becomes 88 lakhs. Now that amount, they have been penalized. So that order.
Penalized by whom?
Penalized by the Assistant Labor Commissioner.
Does he have the power?
Yes, my lord. It is under the Industrial Dispute. It is under the Payment of Wages Act.
That is what I'm challenging, Lord.
Yes, that is what ITC is challenging.
And I'm also challenging that we have paid him, he has refused to accept.
Payment of bonus.
Lordship will see at Section 15(3). Payment of Wages Act.
That will kindly see clause 15, subclause 3.
So can the question of retrenchment has been done or not be decided by the Assistant Labor Commissioner?
No.
My question is there. If that fundamental is not there, how can you go into that?
My lord, the
Whether there has been a retrenchment or not, wouldn't that be a dispute coming under ambit of Section 10?
Yes, Lordship.
To be decided by the Industrial Tribunal or for the matter?
That has to go under Industrial Disputes Act.
That issue was not decided as in the second round of litigation.
No, understood. Therefore, how can he decide that the retrenchment is bad? They have said that this is the retrenchment benefit given to you. You may not accept. But they have considered it to be a retrenchment. Whether the retrenchment was proper or not is a question to be decided by some authority.
That has been decided earlier, my lord.
No, Lord.
My lord,
Who can decide that?
No,
Mr. Mohammed, who can decide whether the retrenchment is right or wrong? Can the Eastern Labour Commissioner decide that?
But my lord will kindly see at page 28. Once for my sake, my lord.
No,
Kindly see
no.
at page 28.
No, if they give you a retrenchment of some 1 lakh,
My lord.
rightly or wrongly, they have said that you have been retrenched. And therefore, we are paying you this amount. Now, can the Labour Commissioner or the Labour Court, a Labour Inspector or whoever it is, decide that aspect? My question is that if there is no retrenchment, a legality of the retrenchment not gone into, how can there be? Yes, tomorrow if it is held that there was no retrenchment by an industrial tribunal, then you have to go under 33C
Yes, which has been done.
for ascertaining. 33C before the tribunal.
Yes.
The tribunal will then ascertain the amount and then it will go under 33(2)C for the purpose of enforcement. It will go to the Bakijai.
and
If I'm not wrong, that is the procedure.
yes, and there's no, there was a conciliation, there's no failure report. Only if there's a failure report in the conciliation, will the matter be sent back to the government to refer it to the tribunal. All these exercises at the conciliation,
And the
everything came to
question
an end.
therefore is, isn't it, madam, that whether there is a retrenchment or not?
That's only the tribunal can decide.
My lord, the conciliation proceeding, this issue was decided in presence of both the parties and both the parties have agreed, my lord. At page 33, my lord.
Now, understood.
Clearly stated.
Let both the parties agree
Yes,
that there is a conciliation out there and this is the award.
yes.
Has there been an award to the effect?
My lord, there is an award.
Where is that?
The
Well,
30th is
because
not an
it-
award.
It is not an award, my
It's
lord,
not
but
an-
they
it's a
have asked
conciliation
to
proceeding.
arrear salary.
Econ Direction?
Conciliation proceeding.
Industrial Dispute Section. There we go. Section 11 what? It has to be reduced into an award.
No, it's not an award, it's a conciliation proceeding, it's not a failure report, Lordship.
Only come to section 12(3)
My lord,
of the Industrial Disputes.
my lord.
But this has to be sent to the government. Thereupon the government, on the basis thereof, it will be settled. If no settlement is reached in a year, send the year to the government
Yes.
for remand and a year. if on consideration of the report under subsection 4, the issuance or report under this section shall be submitted within 14 days. Approval of the consideration, the time for submission of the report may extended so and so. Has the government done anything as regards this conciliation report?
Nothing.
My lord, that the government will only.
So therefore, how does it attain any finality, the conciliation proceedings?
Nothing has been done by the government, Lordship.
But as per the affidavit filed by the government, my lord, they have stated that based on the conciliation proceeding, it was taken cognizance by the government, and thereafter, when they failed to pay the amount, thereafter I filed the second complaint. Then they took cognizance of the second complaint and.
So therefore, conciliation has been done to that effect. So once you file the second complaint, isn't this a case whether there was a rightful retrenchment or not?
No.
No.
It was only
No,
for
when
payment.
they say that we are giving you 1 lakh for retrenchment compensation, you have not accepted,
Yes,
doesn't lead to a dispute.
but my lord, there was two parts. In the conciliation proceeding, the issue that was decided was regarding the arrear wages. As regarding the issue of retrenchment, my lord, it is clearly stated that, my lord, will kindly see page 33 once.
833.
33.
In continuation of the conciliation proceeding, the final phase of EIL meeting arrived at in so and so about
My
3 p.m. on the issue of non-payment of month salary of so and so to him.
Yes.
Now where is that?
And my lord will.
The areas of so and so admissible area will be paid by the management within 1 month, so and so, the conciliation here. So it is only as regard payment of salary.
Yes, regarding the issue of retrenchment, at page 33, your lordship will kindly see from the last 10th line, from the last 10th line, 6th February 2017, your lordship got it, my lord?
Hmm.
Page 33,
So the final phase was held today over the only issue.
yes,
The only issue was non-payment of the due monthly.
my
So
lord,
there was a direction to make the payment.
yes,
So this is ended.
Yes.
So you got that money.
no, my lord,
Okay. They paid you. You did not receive it.
yes,
Okay. Now they also paid you certain amount towards retrenchment. Now you have not accepted that. You're not accepting it. Isn't it a dispute? If it is a dispute, isn't it to be adjudicated by a labor court? Can the Assistant Labor Commissioner decide that? The power is given only to the tribunal under 7A. Am I wrong?
Yes, correct, Lordship. Because the conciliation, there has to be a report, either failure or
No,
success.
whatever may be, the conciliation was only in respect to non-payment of that amount.
He did not decide on one part, on the retrenchment portion, he did not
He
decide.
did not decide. So it was
So
only
either he
on one
reviewed
part.
it-
So you made that payment, he did not accept it.
He did
It's a
not
different thing.
Uh-huh.
But you also went ahead that we are also paying another 1 lakh towards retrenchment benefit,
Yes.
which he did not accept it. So if he doesn't accept it, isn't that a dispute?
No,
It will be a dispute.
it will be a dispute unless he raises it.
Understood. He has to either raise the dispute. So he has raised some dispute, but you should have moved on the 2A.
Absolutely.
my lord, the issue of retrenchment was decided in the conciliation proceeding.
How can it be decided when it is in the conciliation categorically only issue is non-payment of dues?
But my lord, after.
Mr. Mohammed, how can we go into other aspects where it is said, so the final phase of conciliation meeting is held today over the only issue, non-payment of the dues monthly salary of so and so.
But before that, my lord,
No, that is not decided. That's only an observation, but not. a-
That is an observation. This is what has been decided.
but my lord, will kindly see the line, my lord. The management averred that Monor Hussain has been retrenched from service and he is not entitled to anything except retrenchment benefits. But the management failed to produce any valid
Hey,
document.
you have therefore moved this authority under an application under 33C of the Industrial Disputes Act.
My lord,
Whom have you moved?
Lord,
The secretary.
my lord.
This is not done. Entire
The
process
Assistant
has
Labor
gone for a
Commissioner.
6.
Thereafter it was.
Okay,
Thereafter it was-
anyway, file your affidavit. You want to file affidavit, but bad case, Mr. Mohammed.
My lord,
Who wants to file reply one?
Lordship, we filed a reply. He has
You-
filed a reply to a reply. So.
How many reply to reply business?
And we have.
Only one.
The issue is very small.
I filed my opposition, he filed a reply.
That's it.
And then in other cases, they have filed oppositions which copies has not been served on.
Give it to them. When we need to finish up before the year in this type of matters.
Yes, Lordship.
When?
And whenever, Lordship's convenience.
That case, Mr. Mohammed, I think we should give you that liberty to go there.
Otherwise, my lord, since 2016, he has not been paid a single penny.
But he has not worked either.
That is the sad part,
Yes,
na?
sir.
That is the sad part. These matters are to be given due urgency.
My lord.
So we have it on 9th of December.
My lord.
Taking into account that the matter requires an urgent disposal, list this matter on 9th of, list these matters on 9th of disposal.
Yeah, Lordship, can it be on the 7th of
Final.
December?
Huh?
7th of December.
9th.
No, 7th is Sunday.
What?
After, Lordship, no. 11th of December, Lordship.
Thursday.
11th of December, Thursday.
Hello. Who wants to file reply?
My lord,
You want to file?
We have to file in one and then they have to give us copies.
You want to file a reply to them
Why? Into the,
in the petition?
in my petition,
Mr. M. Hazarika submits that reply. Learned Senior Counsel appearing on behalf of the writ petitioner in WPC number 5398/2023 submits that the petitioner would like to file a reply to the affidavit in opposition filed
of
by the
Assistant Labor Commissioner of Respondent number 3.
respondent number 3 to solicit this matter only upon such affidavit in reply is filed.
my lord, can it be dated be fixed? Otherwise,
No, it's interim order is there.
no, my lord.
Oh.
In case of ITC, there is an interim order.
Okay, interim order has been, I'm not extending it.
My lord.
It's already there.
Do whatever they like.
That's why
In
I'm
Lordship,
asking-
18.9,
No interim order extension. Fixed date not taken. No.
Lordship, let it be taken up on the 11th
No,
or even tomorrow. I mean,
no,
tomorrow.
let it go. No time. Next. Yes, item number,
Lordship, if the Bakija is not stayed, I am in a mess.
ITC is a big company.
No,
You
but
pay
Lordship, not 82 lakhs.
82 lakhs, you pay more. You have a good case. You should have in fact said that you should have done it.
I'm ready to do it even now, Lordship. I'll do it even now. I'm
You
absolutely.
were only asking for filing reply.
I'll not
I've
fight.
never said
If-
so.
Without a reply, I'm fine, Lordship.
So
Even
the
without a-
matter could have been done easily. It was a small issue out there. The matter, your basic cases, I have pointed it out. You have forget about other aspect. There is no adjudication.
Lordship, Lordship, I'll
The
do it right now.
adjudication has to be done only by the industrial tribunal.
Lordship, I'll do it right now. I have no problems.
Okay. Showing urgency matters to be listed on 9th.
Tell him to continue, Lordship.
Interim order passed in the writ petition shall continue till the next. Yes, what is this?
This matter relates to non-payment of outstanding dues of the supplier.
Police.
And the amount, some amount is admitted, my lord, by order dated 22/9/2000, annex R is, my lord, page 44.
Is this police?
Yes, my lord.
Police affidavit?
My lord,
Madam. Madam Udas, what happened in this matter? Police, how much? 16 lakhs?
18 lakhs, my lord.
Huh?
18 lakhs 96,000, my lord. And thereafter, my lord. it is
16 lakhs.
16 lakhs 96,000.
Hey, it is given out here 16 lakhs.
Clarifying, ma'am. That's
We have already paid my lordship will be pleased to peruse my instruction, my lord. We have already, now its dues is 10,87,398.
Let me clarify, my lord, what is.
Don't clarify anything more, go before the civil court.
Bills were in two parts, my lord. Stationary articles and spare motor parts. No,
So you say that 12 lakhs, 20,566 is remaining.
No, my lord, in that bill, my lord, 1,33,168 paid, my lord.
Ah.
First pay portion, so 10,87,398, my lord, that remain, my lord, that we are
The
to pay.
rest amount is under scrutiny, 1087.
And my lord, the next bill, we have paid the entire amount, 42,713 and 1,85,895. Total 2,28,608 has already been paid. So in that bill, my lord, nothing remains, but only the this stationary articles bill, my lord, 10,87,398 remains, man.
You file a affidavit.
My lord.
Miss Yuda submits that she has received the instruction and will be filing the affidavit in a week's time. List this matter on 10th of December 2025. In the meantime, the affidavit be filed.
Gotcha.
Yes.
With regard to item number 17, I am very sorry, my lord. I was in legacy in court number 2, my lord. Wherein the
Your
order
person has
itself
gone.
reflect- Absolutely, my lord. I seek apology for that, my lord.
We will meet you, have you on the day, 1st of December. The
Yes.
person has gone. You get so low of him and bring him, then only I can do anything with that order.
No, my lord, I have talked to him, my lord.
No,
What I-
no, he has to be present. Otherwise, no. I'm not going to hear you.
My lord, I'll try to, my lord. I'll try.
23.
My lord, the date may be changed, my lord. First, I will not be there. my lord.
Unless he comes.
He is there. Yeah.
Item 23.
None appears for the petitioner. What is this?
My lord, it is regarding running of a ultrasound clinic, my lord.
What does he want?
Impugn order is at page 32, my lord. My lord, because the person concerned did not fulfill the requisite qualifications as prescribed in the act, my
It seems that the petitioner has not appeared for the third time. None appears on behalf of the petitioner. On the earlier occasion also, the petitioner did not appear. Considering the above, it seems that the petitioner is no longer interested in the matter for which the writ petition stands dismissed for non-prosecution. Interim orders, if any, stands vacated.
Obliged, my lord.
25.
What is this?
My lord, by the impugned order, an amount of 45 lakh has been recovered for me by the FCI. That is under challenge. my lord.
You have filed reply also.
My lord,
Yes,
right.
my learned friend has filed it today.
Today.
Okay. You got a stay order?
No.
For recovery?
They have recovered.
You want the money back?
Money.
Or interest?
Money back with interest of the.
How much interest you are asking?
If I succeed, my lord,
You are an MSME?
my lord,
Are you an MSME? Mr. P.K. Roy, the learned senior counsel appearing on behalf of the FCI submits that a petitioner has filed an affidavit in reply today and a copy thereof has been furnished to him. He therefore submits that some time may be granted so that the respondents can go through the same.
Yes.
Considering the above, list this matter when? Before December, after December?
before December, lordship.
There's a lot of other matters. There's no surge urgency. This matter again on 21/2026 at 2 p.m. for final disposal. I'm giving it for final disposal on 21/2026.
Not. Item 26, 20th of January. 21st.
What is this?
Ma'am,
How many?
lordship,
Lordship, the petitioners here is the outsourced security guards, my lords. So basically, they were employed in the sites of APGCL. My lords, time and they've been working since the last 15-16 years. They worked at the site of APGCL, but the contractors used to change, my lords.
Huh?
They used to work at the site of APGCL, my lords. However, the contractors used to change from time to time. They used to stay there. The problem that has arisen here today, my lords, is this, that the respondent number 9, their work contract was till 31st June 2024, my lords. Therefore, my lord, there have been a lot of conciliation that has happened between APGCL, the trade union of this outsourced security guards, and my lords, the respondent number 9, that is VSSS, my lords. And thereafter, my lord, there are some back wages that has to be paid, the VDA. My lord, that was not to be paid. First grievance being that, my lords. Second grievance being that, my lords, the new contractor that has come, my lords, that's NESS Private Limited, my lords, that is in, they have hemmed it as an employment agreement that we will retain you provided you sign this agreement, which is in page number 80, my lords. So, my lord, they include two clauses. First clause being the one of the clauses being that you cannot form an association if you work with us. Secondly, my lords, if you have to work with us, there's a clause number 11 which says that you have to deposit a 1 month salary for our administrative expenses on the very first month, my lords. So the grievances here being twofold, my lords. First, that the back wages not being paid, and secondly, the unconstitutional agreement, my lords, which has been.
Who is NESS?
NESS, my lords, is the new contractor which has been employed by APGCL to look over to hire the outsourced security guards at the site of
So it's a
APGCL.
private contract.
Private contractor.
So if it's a private contract, how can we enforce under 226?
My lords, because first of all, if I just may bring, my lords, page number 80 and 81.
I understood, but how can this court look into that aspect?
My lords,
Okay, as regards some surgery, was some letter of APGCL, it's okay, but how do you bring in NES?
my lords, because there has been.
You have a problem with NES, go to the industrial tribunal. There are many other ways by which you ventilate. But how can this court under 226 look into the terms and conditions between you and me?
There another contractual agreement, my lords, in para number 11, which they says that, my lords, if we see the, my lords, the jurisdiction of industrial tribunal, my lords. So basically, they are trying to enforce an agreement which is unconstitutional in nature.
Absolutely, but how do I do it? I would have understood if it is on the direction of AGCL. If it is done under the direction of AGCL, it's a different thing. This courts can very well interfere. But if it is between you and NES, then very difficult.
And because, my lords, the APGCL is the principal employer.
So what?
Yes, my lords. Principal employer is APGCL.
So can you make out the case that APGCL or whatever it may be, that company concerned have mentioned as the agreement witness that he has to follow some normal labor practice and all, which is there, by which you can bring in.
Yes, my lords, there was an agreement between NESS and, my lords, APGCL, my lords. So basically, in the conciliation meeting that has happened, my lords, if I may just bring to the.
Again, you are going to another
I
aspect.
understand, my lords, that
You try to bring your case within that, where normally these agreements categorically mention. How are you going to treat your area?
yes, my lords.
So look into that. And if you can make out a case from there, then you bring in the list and say that APGCL has to look into it, that it is not in violation of those terms.
Okay, my lords. I have gone through their agreement, my lords.
You try to make out your case on that. Look into it.
Yes, my lords.
This is how, otherwise with NES, this court cannot do anything.
Yes, my lords. And NES also not appeared also.
Ah.
No, I can give 1 week.
NES is not a party?
Is a party but not appeared. I have served Dusty also, but not appeared, my lords.
You are NES.
No, my lord, I am paying for respondent number 9.
What is 9?
VNSS, my lord. The back wages that we talked about, my lords, VNS, DLS allowance.
Very good. So NES has not appeared.
Not appeared, my lords.
Here pays affected service.
And Dusty also, my lords.
Chalo. We have it immediately after vacation.
Yes, my lord.
Try to improve your case on that.
Yes, my lord.
So none has appeared. NES is what is the party?
Respondent number 10, my lords.
none has appeared on behalf of the respondent number 10, in spite of service having been meted out. Mr. So-and-so appearing on behalf of the petitioner submits that the matter requires an urgent disposal, taking into account that the petitioners herein are not being employed by the respondent number 10 on certain for reasons which is completely ultra vires the constitution. So, taking into account the urgency expressed, list this matter on 27th of January 2026 at 2 p.m. for final disposal.
27.
Pledge ballots.
Please, your lordship.
So file your reply.
Yes. You have not received.
What is your stand? What is your case about?
Not, we are saying that this was not, these proposed notices were never communicated to us, and the communication address is not correct. And then the email ID they have given in this letter.
Was the order dated 11/3/2000 passed by the area, same being illegal, arbitrary and all. What is this 11/3/2024 page?
My lord, 23,
Page?
23.
Okay, now
My lord, they have filed their affidavit saying that they have informed about the,
understood, but madam, don't you think there's a big problem out here with this your matter? How can this court look into all these things?
Yes, my lord.
Possible? They have filed an affidavit that they have duly informed, final show cause notice and all.
my lord.
You have filed a reply. What is your reply? Did you not receive it?
No, my lord, we didn't receive.
The answer B at the EY is also contradictory to the letter dated while the letter dated here. So we have to call for the records.
My lord.
Records can be called. Right.
Produce the records as to whether how you have served it and all. Taking into account the pleadings, it is the opinion of this court that the records pertaining to the cancellation order dated 11/3/2024 is required to be perused. List this matter again on 10th of December 2025. 10th of December. So Mr. Aibot Thakur, the learned counsel appearing on behalf of the PHE department shall produce the records.
28.
So what are you doing?
Lordship. Regarding
The
that,
government otherwise is very strong on evicting from government land,
yes, Lordship,
but here you don't want to do it.
it seems.
Why?
On regarding that, Lordship, that eviction part, Lordship, what steps they have taken, that instruction I have to take, Lordship. Because some reserve part, they have said there, and some individuals has encroached by constructing shops, house.
Now, what does the fish market have to do with Assam Fishery Development Corporation? What does fish market have to do with this fishery department and all?
Chief, actually,
That will come under the district administration, isn't it? What, madam, what business you have with the fish market? Huh? AFDC, what role? They also control who is going to sell what.
This market is also lease, under the lease
Fish market.
by the ABC.
And who are you?
I'm for the petitioner.
That I know. Otherwise, you won't be standing this way. I'm asking you, who are you here? You are a settlement holder of
Fish market.
fish market. So therefore, I'm asking you, does the AFDC have any role in the fish market?
Perhaps that that market has been operated by the AFTC.
So they leased you out.
They got a lease from the AFTC.
And there are somebody else running
Yes, yes. But
and
their
you cannot do anything.
Their contention is that some portion of the debt has not been demarcated. And so far as our instruction is concerned, during demarcation, we
Has
have
been demarcated and it is found that a portion of the land reserved in favor of so-and-so have been encroached by constructing houses in which they are running shops. Do you permit so? You are the district administration.
the Lordship.
Pursuant to the orders passed by this court, Mr. S.R. Borua, the learned junior government advocate, has placed before this court an instruction issued by the Circle Officer Goroimari Revenue Circle, wherein it is stated that a demarcation was carried out in respect to the Totishola fish market. And it was found that certain private individuals have been constructing houses in which they are running the shops. Full stop. The said document is kept on record and marked with the letter Y. Full stop. Under such circumstances, this court, therefore, sought for a query from the respondent authorities, more particularly the respondent number 2, 3, 4, and 5, as to whether in respect to the fish market which have been settled to the petitioner, with the petitioner, encroachment by private individuals can be allowed by the respondent authorities. Let an affidavit be filed by the respondent number 3 in that regard. Fix the matter again on 15th of December 2025.
Earlier, there was a eviction notice was there on 6/2/24. So their pair is also for execution.
Mr. S.R. Borua, we also know when you are interested in eviction, you evict.
Lordship.
And when you are not interested in eviction, you have only a paper notice. So therefore, the answer is, therefore the question query being made.
29.
15.
Yes, what has happened? DRT? Stay going on.
No, no, the case is dismissed now. So DM,
Take steps.
no, we
You
have
take
already approached the DM.
DM, I have made them party now.
Yes, they are
Who is
ready
appearing for
party
the
here.
DM where? DM here?
Yes, Kamrup Metro.
Who is appearing? DM will be the district magistrate, SR Borua. Mr. Borua, just find out what is this. Now they have approached kindly do the needful. Because you are bound in view of the judgment of the Supreme Court in respect to section 14. Take it up. Yeah.
Because our instruction says we were not aware of the outcome of 6/11/25.
Mr. A. Parvez, the learned counsel appearing on behalf of the respondent, Punjab National Bank submits that the appeal which was filed by the respondent, private respondent.
Private respondent.
Huh?
Well, he is not responded.
He's not a party here.
He is not here, mortgager.
No. Filed by the mortgager before the debt recovery appellate tribunal have already been dismissed.
Yes, ma'am.
And dismissed by an order dated
7th November 2025.
7th of November 2025. Full stop. He therefore submits that pursuant thereto, the district magistrate, Kamrup Metro, have been duly intimated the same. Mr. S.R. Borua, appearing on behalf of the district magistrate, Kamrup Metro, shall apprise this court what further steps have been taken in pursuant to the said request. List this matter again on 8th of this, before that, 5th of December 2025 for an update. Next.
December 30. Approach kora hoise.
Let me simple version. Lordship, the matter pertains to release of security deposit money lordship. Affidavits are yet to be filed for this matter.
Lordship, we have sent a draft of affidavit for vetting. Kindly sometime may be given to us.
Yes, who is appearing? Water resource.
No. AG.
What is your case?
Lordship, sometime may be given. We have sent our drafted affidavit for vetting. Sometime may be given for
When are you filing it? It has gone for vetting.
Yes, Lordship.
So you can file it in within 1 week.
Yes, to the
Yes.
CAG office.
Ms. So-and-so appearing on behalf of the Water Resource Department submits that the affidavit can be filed within 1 week. List the matter again on 12th of December. In the meantime, the affidavit be filed on or before 8th of December.
31.
I have not received my instruction, my lord. If you allow me 2 weeks time to file my affidavit. I have not received my instruction.
You have not filed the affidavit?
No, no.
Why?
Time was given till 17/11.
My lord, initially I was not appearing in this case, my lord. Instruction has not come, my lord. So allow me 2 weeks time to file my affidavit.
Mr. Bora, are you not a standing counsel
sir,
of
no,
the
that's-
SCMC?
That,
You keep on changing. Tomorrow, Mr. Naik will appear and he will say that on the last occasion, Mr. Bora was there, so he did not intimate me. Can that be the ground?
for this case, only when our case is allotted, my lord.
We are concerned out here, Mr. Bora, in this case, if I remember correctly, is a case where there was already a direction being passed by the another coordinate bench.
Lord,
And thereupon you have initiated certain further action in derogation to the order passed by the learned coordinate bench, which is a very serious issue unless you seek a review. Have you sought for a review of that order?
no, that,
Then why you're not paying the amount? The direction was to pay within how many months? 4 months, 3 months, something like that. This is not done. Next week you produce the head of account of the GMC. We attach that.
no.
A lot of GMC has money. You have money?
No, I don't know that.
No, GMC has money.
The AMC is serving on the state government's mercy.
Okay, very well.
My lordship will allow 2 weeks time, I will file my affidavit.
Don't file. Next time, if you don't file, this is not. A final, Mr. S. Bora appearing on behalf of the GMC submits a final opportunity may be granted to the GMC to bring on record the stand. List this matter on 12th of December 2025. In the meantime, the respondents, GMC shall bring on record their stand by filing the affidavits on or before 10th of December 2025. It is observed that this being the second round of litigation, if the affidavit is not filed as per the dates so fixed, this court shall proceed to dispose of the writ petition on the basis of by applying the doctrine of non-province.
15th, my lord. 15th.
Why 15?
Well,
12, what is
we have
there?
had some difficulty.
Did
on that.
you ask Mr. Naik?
Lordship will-
Okay,
15.
15.
15.
File it.
Okay.
32.
Ah,
Lordship, here my
Mr.
instruction,
Azhar,
instruction is that.
why you are not holding this?
SD money.
SD, however, the same has not been paid.
Lordship,
What
it
is your
has been
response?
forfeited as per my instruction, Lordship.
Huh?
The earnest money has been forfeited, Lordship.
Forfeited?
Lordship,
Why?
because he has not completed the work, Lordship.
Oh,
And it was intimated to him, it was written to him, Lordship. Second page, Lordship, kindly see the
Huh?
petition. It was intimated to him into the 23
with
itself, Lordship.
reference to have the so-and-so, the due to a contractor against there has been released in connection with the so-and-so, so-and-so, so-and-so. The total bill work done by the contractor is rupees Iman. It is to be mentioned that the total bill of rupees received from the Iman and no outstanding payment. What the value in his queue is so-and-so. The contractor has not been able to allocate work fully.
Next page, it is written to him, Lordship, in fact. The
Ah, it has been informed to you
Yes,
on
it was
21
informed-
two.
yes,
No, my lord. Not communicated.
It's Lordship, kindly see, Lordship, this is the letter.
Chalo, it has now been communicated to you. So now because of that, you file suit.
My lord, he say earnest money. My, earnest money forfeit, man. Earnest money and SD money is different, my lord.
Same.
Earnest money is 2%, my lord. Before entering into
It is
agreement.
clearly said, Lordship, earnest money, etc., Lordship.
Huh?
You and the earnest money, etc., deposited against the work is hereby forfeited. The letter dated 21/2/23 clearly says, Lordship.
Works of the aforesaid hereby withdrawn from you and the earnest money, etc. deposited against the work is hereby.
Yes, Lord, clear.
Lehok heard Mr. A.K. Azad, the learned counsel appearing on behalf of the petitioner. The instant writ petition has been filed by the petitioner seeking a direction from this court for direction upon the respondent authorities to refund the security deposit to the tune of rupees 3,89,084 in respect to the work pertaining to paragraph 52 আগৰ orderটোত লেখা আছে। Mr. N. Upadhyay, appearing on behalf of the Irrigation Department, submits that the work in question was not completed by the petitioner. And as such, the balance work of the aforesaid work order was withdrawn from the petitioner and the earnest money, etc., deposited against the work was forfeited as per the tender agreement. He further submitted that this communication was duly intimated to the petitioner on 21/2/2023. The instruction so placed before this court is kept on record and marked with the letter X. Taking into account that by the communication dated 21/2/2023, the earnest money along with all other etc. having been already forfeited by the respondent authorities, the question of any directions for payment of the security deposit cannot be made Accordingly, the instant writ petition. Accordingly, the instant writ petition therefore stands dismissed. Before parting with the record, this court, however, observes that the dismissal of the instant writ petition shall not preclude as well as prejudice the petitioner to approach the competent court of civil jurisdiction if so advised.
Obliged, Lordship.
So advised and permissible under law.
Lordship.
What is this? Siltek Mara Katigora Iman. Oh, this one.
Yes, madam. After last occasion.
What happened, madam?
Lordship, we have communicated with the department, but instructions waited. We have communicated with the
CEO?
CEO, Lordship,
But they are not intimating.
Lordship. So kindly, 2 weeks time may be given.
No, we asked the CEO because they, as you have intimated, they have not done it. So, okay.
Lordship,
This court had issued notice on 12/11/2025 seeking instructions from the respondents numbers 1, 2, 4, 5, 6, and 7 as to why no tender proceedings have been initiated for settlement of the Sialtek cattle market under Katigora development block in the district of Kachar. Ms. N. Bora, who is the standing counsel of the respondents, submits that although instructions were sought for, but the said respondents have not intimated. Considering the above, it appears therefore that the respondents are not inclined to take the services of the standing counsel. Under such circumstances, this court fixes the matter on 8th of December 2025, on which date the Chief Executive Officer of Kachar Jila Parishad shall be present through the video conferencing mode at 10:30 a.m. The link to be provided by Ms. N. Bora, the standing counsel of the PNRD department. It is, however, observed that if the instructions are provided on that date, the Chief Executive Officer Kachar Jila Parishad need not appear.
but Lordship, there has some technical issues because.
Madam, you just give this order. Next time, I have not asked him to appear. He will provide the instruction, he need not appear.
Lordship, I will provide instructions.
That is why I said, once you give this type of order, then they will be more clear. Next time onwards, they don't do all these things.
Yes.
I am empowering you, madam. I am empowering you. Then they will listen to you. Otherwise, I also know, you also know. What is this?
Subsidy matter, Lordship. Subsidy matter, Union of India has filed the affidavit today.
What matters are these?
Non-payment of subsidy, Lordship, settle insurance subsidy.
Subsidy, 2009-10. Matters filed in the year 2025.
Lordship, we have been corresponding with them. We have been having correspondence with the department. Ultimately, when they have not proceeded, then we have filed a reply.
Okay, who has filed reply? You?
Today itself, morning,
Okay.
Industry department is supposed to file.
Payment is to be made by the state government. Has the state government filed?
Not yet filed, not yet.
Why the state government is not interested? It is seen that the Industries and Commerce Department of the government of Assam have not filed the affidavit. On the other hand, the central government as well as the NETFI have duly filed their affidavits. Considering the above, list this matter again on 21st of January 2026. In the meantime, final opportunity given to the Industries Department to Government of Assam to file their affidavit on or before 19th of January.
My lord, non-payment of bills, my lord, it can be disposed of, my lord, as per my lord Ali's judgments, my lord. Urban Development Department, my lord.
Okay. I do 1 month verification, payment Tamser Ali, disposed.
Deeply obliged.
Where is your counsel? Other side counsel?
Yes, he's coming, my lord. 62. 62, my lord, same non-payment of bills, my lord. I don't have the file, my lord. But Tamser Ali, my lord,
Okay.
can be disposed of.
My lord, one more aspect is there, at the last page, my lord, page number 208, my lord. Regarding the fund, my lord.
This is a communication.
This communication was by this office of the district commissioner, my lord, to the engaged counsel of the petitioner, my lord. It's a reply of the legal notice. My lord. So there was no fund basically. So that aspect may be considered, my lord.
What? They will put it in the chronological list and pay.
My lord.
1 month verification, then put you in the chronological list.
Yes.
My lord.
This is how it is.
Yes, deeply obliged.
Disposed.
My lord. Maybe within 3 months, my lord, if possible, my lord.
What?
Within 3 months, if possible, my lord.
What? Payment?
Verification, my lord, yes.
1 month. Verification is 1 month.
3 months,
Verification is 1 month.
my lord.
Payment is as per Tamser Ali.
Obliged.
Verification
63.
is 1 month. Payment is Tamser
Much
Ali.
obliged.
Yes, what is this? Petitioner's hotel. Why you are not allowing the petitioner hotel to run?
Yes, yes. But we have,
Send to the senior subpoena for verification. In the meantime, senior is like to verify and submit a report to the district commission and residence shall thereupon intimate the petitioner as regards the decision. Yes, what steps have you have taken?
yes, Lordship, the senior SPF.
Representation, what has happened?
Perhaps that has not yet been decided because one report has come from the office of the SSP that they have not closed down the shops. So it SB, senior superintendent of police has sent one report to the district magistrate that they have not closed down the shop. So it is under the domain of the district administration. And for trade license and all, the office of the district commissioner has issued letter to the BDO. So, Lordship, may kindly allow 1 week time, Lordship, so we'll have concrete instruction on this.
No, you have already closed this, isn't it?
Yes.
It is closed.
Yes, but not closed by the police authority.
No, they have closed it because of selling beef. No?
Yes, yes.
Now he doesn't want alleged beef.
Yeah, LSB.
Alleged beef. He is not pura beef. So 1 week.
Lordship.
The instruction as sought for by this court by the order dated 31/10/2025 have not been provided. Considering the above, list this matter on 1st of December, on 5th of December 2025 for an update. 5th no koribo,
Dated at
on
65.
8th of December. Huh?
Item number 17, my lord, counsel is there, my lord, junior counsel, my lord, in that case.
Okay. Here, what is your instruction?
Only, my lord, 5th, my lord, and within the 5th, my lord, my instruction will be here, my lord, in writing, my lord, before this honorable court.
You see, I have asked for an instruction of 2210.
Yes, my lord.
And what is the instruction sought for is that there is an inquiry report which you
Absolutely,
have
my lord.
enclosed to the
They were
affidavit,
sitting over the-
additional affidavit.
Yes,
That the inquiry report is dated 26/2/2025.
absolutely.
My only instruction sought for is what steps have you taken pursuant thereto? Because you said that you have not been able to find out what is the rate of supply and all.
Yes.
And you are going to verify.
Yes.
What have you done thereafter?
Yes, my lord. With
When?
regard to this, my lord, the instruction that is been sought for, my lord, that the person who has been conducting the, my lord, he is not there.
Not
He has been brought
necessary,
to-
but
A subsequent person came into that.
whoever
particular
it
place.
is, that means you have not done anything. Your shop is closed, na? Something is wrong. Yes. Something is wrong with him.
So may I pray, my lord,
So the-
let it be fixed on fifth, my lord, I definitely undertake, my
I
lord.
give it
my
on
works.
8th.
Eighth. my lord.
List
Deeply
this
obliged,
matter on 8th of December 2025, on which day Mr. A.K. Bhuya, the learned senior standing counsel of the BTC, shall apprise this court as to what steps have been taken, shall apprise this court as regards the instructions sought for by the order dated 22/10/2025. Have the item number given us?
17 by 7. Deeply obliged, my lord, deeply obliged.
Yes, what is this? Oh, this one.
That's today the IOCL has filed an affidavit during the course of the day. In the affidavit, they have in fact admitted that the scheme was discontinued, but they were not aware of it after the tender process had started. So, and some banks have in fact, they have informed in the affidavit that some banks have written to them saying that since the scheme has been discontinued, the earlier confirmation letters which had been given, they cannot be given effect to. So perhaps those letters of acceptance have been cancelled.
So, my lord, those banks have replied, the bidders have been cancelled. The respondent number 6 here in the Bank of India, they have not yet replied to us. So if.
Who is
depending-
paying for the Bank of India?
My lord, there's no, I don't know if it's a standing council, there's no.
But
standing-
have you taken it up with the Bank of India?
We have written to all the banks and we have reminded them also. Bank of India has not replied back to us. Other, for example, if my lord takes
But,
up.
but the fact remains
Yes, my lord.
that the scheme have been cancelled.
Yes, that is true.
So under such circumstances, you have to take action in accordance with law.
Yes, my lord, because. My lord,
Because you cannot give
Yes.
that benefit then.
No, that it is impermissible. Even if they get another benefit, another.
Who is
scheme,
paying for
we
the
can-
private respondent?
Yes, Your Lordship. Lordship, as.
There are just before my learned friend begins, he is appearing for the newly included private respondent.
Yes, Your Lordship.
I am not challenging his bid. He is in a different tender in Manipur, in a different category. This is not the subject matter in this petition, perhaps. So, subject to what my learned friend says.
May I please, Your Lordship? Your Lordship, as regards the affidavit in opposition filed by the IOCL, Your Lordship, I have not received a copy of it, Your Lordship.
You're not entitled to.
Yes, Your Lordship. However, as regards, Your Lordship, the whole contentions of the petitioners, Your Lordship, that the credit guarantee scheme for Stand Up India, which is only for startup enterprises, Your Lordship, that only has been cancelled or that has been only discontinued. Whereas on the other hand, we fall under credit guarantee, Your Lordship, fund of trust for micro and small enterprises. That is a different credit guarantee, Your Lordship. The Stand Up India scheme, Your Lordship, facilitates loan who are eligible under the micro and small enterprises. And we also fall under that particular micro and small enterprises. And according to our humble submission, Your Lordship, there has been no cancellation of CGT MSC, wherein we fall under, Your Lordship. And in this matter, learned senior counsel, Mr. Kane Chaudhary, sir, is also appearing, Your Lordship. Kane Chaudhary, sir, is also appearing, Your Lordship.
Mr.
Kane Chaudhary, sir, is also appearing. He's on legs, Your Lordship.
Standing counsel.
Yes, senior counsel, Your Lordship. Your Lordship, so the CGSSI, which has been discontinued for startup, Your Lordship, would not be mean that, Your Lordship, the whole Stand Up India scheme
No,
has been
but tell
discontinued.
me, that scheme
Yes, Your Lordship.
categorically mentioned whom? Whom do they refer to? I passed the impugn order, na? Some order, interim order, not some order I passed. Where is that?
The order of 25/9/2020.
वो भरा दी है Pasta 25/9. I said something about Stand Up India scheme.
Yes, Your Lordship.
So Stand Up India scheme is there.
Yes, Your Lordship. So Stand Up India scheme, Your Lordship, is the main scheme which facilitates, Your Lordship, loans to the bidders who cannot offer, Your Lordship, collateral security, Your Lordship. And in that particular tender as well, your lordship, wherein we have participated from the state of Manipur, your lordship, there also have been a particular reservation clause.
We wish to inform that the credit guarantee scheme for Stand Up India has come to an end on 31st March 2025.
That is only for your lordship credit guarantee scheme for startups, your lordship. If I may.
Where is the startup?
Yes, your lordship may very well peruse page number 206, your lordship, of the affidavit in opposition filed by respondent number 10, your lordship. There has been a categorical distinctions as regards, your lordship, the various schemes, even CG.
206
Yes, your lordship. I'll just take your lordship to
Stand Up scheme.
page number 214, your lordship, of the respondent number 10's affidavit in opposition, your lordship.
Who is respondent number 10?
Yes, your lordship, the newly implemented, your lordship, respondents, your lordship.
This is only for startups.
Yes, your lordship. And if your lordship peruses page number 209, your lordship, we fall under, your lordship, micro and small enterprises, your lordship. There has been no such
Credit
notifications
guarantee
as such.
scheme. No. You see, let us see the tender condition.
Yes,
Where
your
is the
lordship.
tender condition?
Yes,
where
your
is
lordship. May
the
very
tender
well peruse
condition?
their petition.
Tender condition?
Tender of Stand Up India, your lordship. Yes,
Condition.
yes.
Got it.
Page number
Page
45.
45. SC/ST bidders putting under the Stand Up India scheme of government will be allowed to propose maximum of 2 trucks per bidder on industry. This is only available to SC/ST bidders only.
Milord, I think the petition has been structured on the basis that only under a particular scheme it has been stopped, Milord. I'm just getting my file, Milord. Actually, the position is not like that as is sought to be projected. Because there are about 5-6 schemes. And in the sanction order given by the bank, those are clearly mentioned. Thank you, sir.
And in respect to the respondent number 7, where is that document?
We are appearing for response
No, understood.
10 and 11, Milord.
Where is the respondent number 7?
The response number 7 was issued a confirmation letter by the Bank of India, which your lordship will find at 157. Bank of India has not cancelled it yet. Now, one thing which
Milord, I may clarify the position, Milord.
they have participated in different tender, your lordship, in Manipur.
Certificate is issued at specific request of the customer.
In that tender, there may be other categories available.
No, here same aspect. If your lordships will kindly take our affidavit, Milord, we got ourselves implemented in this proceeding as respondents number 10 and 11. Now, if your lordships would kindly come to page number 213 of our affidavit. The 213.
No, Mr. Chaudhary, I've looked into it.
Yes.
Just now I've looked into it.
Yes.
So there are 214.
Yes,
This is for
214.
startup.
Hmm.
Provides collateral so and so.
Yes, yes.
So who is the best person to give us a good idea on this?
A Government of India, Milord, that department.
Who is appearing for the government of India? Hello. Government of India.
For a moment, if your lordship would kindly come to page 215, Milord.
Government of India, none is appearing. Ne?
215.
Government of India party.
Yes, as a party coalition.
Yes, Government of India is also a party and the National
Credit Guarantee,
Trustee
five. In fact, Milord,
I will not appearing.
5 has not entered appearance here.
Milord,
Otherwise-
5 is the main party to
Main
answer.
party. Because this communication, if your lordship,
5 APL call.
sir, lordship may have this letter at page number 138. This was issued by respondent number 5 on 28th March 2025, on the basis of which all banks have cancelled the SUIS category confirmation letter.
No.
With reference to our letter number so and so, we wish to inform you that the credit guarantee scheme for Stand Up India has come to a close on 31st March 2025. In view of the above fresh guarantee.
Lordship is absolutely correct, my lord. Some clarity is required. I was engaged yesterday, having gone through. I also felt, my lord, some clarity on the different scheme is required, my lord. Because if your lordship would kindly come to page 215 for a moment, these are the different schemes, Miller. And we have been sanctioned under TMSC.
No, wait, one thing. Let's get a clarity from them
Yes,
in respect to what do they say about SUIS category? Do they only say about startup or credit? There are many.
yes. Well, we have been given under CGTMSE. That means Credit Guarantee Scheme for Medium and Small Enterprises.
Ah.
We are covered by that MSME Act. And what my learned friend petitioner is referring to is Credit Guarantee Scheme for Startup India.
In fact, if your lordship has
For
one clear,
Stand Up India.
Yes,
Startup India or Stand Up India?
stand up India.
Stand Up India.
And you are under?
I am under Milot Central Credit Scheme for Medium and Small Enterprise. That is CGTMSE at page 215. Of my
Understood.
affidavit.
But here in clause number 42,
Yes,
page number 42, they refer to what scheme? Stand Up India scheme.
Stand up India.
43.
page 43, yes.
SC, ST bidder offering
SC, ST and
proposed
women.
trucks under the Stand Up India scheme.
Yes. SUIC. Now this SUIC has Milot various classifications, different kinds, Milot. And we are under CGTMSE.
Now, you have been already granted contracts in Manipur.
Yes,
You are worried out here because of the declaration which they sought for in
that may affect
relief
us
number
very
C.
initially, yes.
Now, in your contracts which you have been granted, is it in respect to SUIS, some MSC or something? Because you are for there.
Yes, yes. If your lordship would kindly come to my affidavit, Milord, the bank letter, when they agreed to provide the finance at page 240.
This is women.
250, Milord.
Huh?
Sanction letter is at 250. In fact, it starts at page 249, Miller. 3/10/25.
When was this issued?
It was on 3rd of October 2025.
This one?
Yes. And page 250, Miller, it clearly mentioned the term loan at page 250, security, term loan exposure shall be covered under CGTMSE guarantee coverage.
Where? Page?
3, security, third column, Miller. Purpose, then
So this
security.
is different. This is not CGIS, SSIS.
No, we are covered by this, Miller.
No, this has no relation out here.
No. In fact, the
Now, what is the term of this contract?
No, Miller, the purpose of the contract is same, but we have been given under a different scheme. Oh, Omen. SUIC Omen.
In the letter of award which has been granted your lordship today, that your lordship will find that
From the
page number
treatment
246.
banks from
Their
Correct.
category is different. We are not challenging that category.
Huh?
We are not challenging that category. Their category is SUIS women, your lordship. At page number 246. That is a part of the letter of award issued to the
I'm
respondent.
going to clarify quickly. If that is clarified, Milord, we are satisfied.
We are only concerned in the SC/ST category.
No, yeah. Corrigendum, page 222. This is some tender.
Corrigendum in respect of tender for bulk soil.
Now kindly come to here, page 227,
Yes, Milord.
the second part. A, SC, ST and women bidders offering proposed trucks under the Stand Up India scheme of the Government of India. SCS bidder offering the proposed trucks under SUI of the Government of India must submit confirmation letter from the scheduled banks for extending loan under the government Stand Up India scheme.
Yes.
Such scheme bidders under NUS on pan-India basis can offer a maximum of two
Two
proposed
proposed
trucks.
tracks either in one bid or maximum of 2 bids. In this
Now,
same state.
this is one thing, but another interesting, this is one thing. But on the other hand, this document is very vague. Page 168 of the writ petition.
Correct, correct.
Because
that's
they
why-
say
Correct.
credit guarantee scheme for stand up India.
Hmm.
So
Lord,
it
some
says
clarity is
everything.
required. Lordship is absolutely correct, my lord. Yesterday, even while I going through, I saw some information which was not readily forthcoming.
This has to be there.
Yes. So I think, my lord.
So this is
respondent
ministry,
number
this is under the
five-
Ministry of Finance and
Ah.
the union is not appearing. So we ask the secretary to be present to the video conferencing link to
Union
be
has also
provided.
been included as a party.
Huh?
The Union of India has also separately been. included as a
No, they are not bothered.
Yeah, five is the right
Five,
person.
five,
to
five.
answer.
The instant writ petition has been filed by the petitioner, challenging the actions on the part of the respondent IOCL. IOCL, na? In extending the benefit of Stand Up India scheme to the respondent number 7, though with effect from 1st of April 2025, the credit guarantee scheme for Stand Up India had come to a close as per Annexure A. What is Annexure A?
Annexure G, your lordship, page 130.
Huh?
Page 130, Annexure G.
168?
168, your lordship.
As per Annexure?
138, your. That is an internal.
As per Annexure G to the writ petition. The service have already been effected upon the respondent numbers 5 and 9. But strangely enough, strangely enough, the Union of India is not represented, whose presence is very essential for an adjudication for the purpose of progress of the instant writ petition. This aspect assumes more importance taking into account the stand of the respondent number 10, who have been granted contracts under the Stand Up India scheme. Full stop. Mr. Kane Chaudhary, the learned senior counsel appearing on behalf of the respondent number 10, submits that the Stand Up India scheme has various facets, various different components, such as woman category, MSME category, startup category, etc. It is his submission that in respect to Stand Up India scheme, startup category, the scheme has been discontinued, but not in respect to the Stand Up India scheme, MSME category or the women's category. Full stop. In absence of this clarification, then this aspect can only be clarified by the respondent number 5 and respondent number 9. Full stop. However, on account of non-appearance of the standing council of the central government council, comma, the matter could not be proceeded with. Full stop. list this matter again on 2nd of December 2025 at 2 p.m. Pusto. A copy of this order be furnished to Mr. R.K. Dev Chaudhary, the Deputy SGI, to obtain necessary instructions. Failing which, this court shall would be constrained to pass appropriate directions for for appearance of the officials, taking into account that for the progress of the instant writ petition, the stand of the respondent number 5 and 9 is essential.
Orders, item 34.
Mr. Pathak, you take a copy and give it to him.
Yes.
This is a big problem we are facing. The central government, these people are not appearing. I think they are shortage of counsel, so I don't know.
I checked,
They-
the names are reflected in the.
They don't appear, they are least bothered. So I think something once twice personal appearance given, then things may move. And we may also ask the law ministry that they kindly have some suitable people who can appear on behalf of the central government, not like these people who don't appear. Chalo. Yes, contempt. 34. Reply affidavit not yet been received. What affidavit? N. Bora, the Learning Council, respondent 6 2 weeks time to file the reply. Chalo. What is the order?
The order is at page number 15, my lord.
Huh?
Start at page 15, my lord. 40% page.
Oh, this one.
Yes, my lord.
What is this you are going ahead? Now, what has happened to the writ petition?
That has already been, my lord, dismissed for non-prosecution. my lord.
Then, have you restored it?
Yes, my lord, I've informed the petitioner, my lord, they are intending to restore it, and they have not approached us, they'll approach some other council. my lord.
Mr. Counsel, that was exactly the question which I asked you last time.
Yes.
Remember?
Yes,
When you took time on the ground of Mr. KP Pathak?
yes.
But as you have not done anything, why should we proceed with this contempt matter?
My lord, informed them, Mr. Petitioner, my lord.
This is against an interim order. Writ petition has been dismissed, so obviously nothing can be done. Mr. Yaho. The present heard Mr. B. Das, the learned counsel, appearing on behalf of the petitioner. None has appeared on behalf of the respondent number. The present petition, the present application has been filed alleging willful and deliberate violation to the order dated 8/4/2022 passed in WPC number 2605/2022. It is seen that the order dated 8/4/2022 is an interim order. During the passage of time, the writ petition has already been dismissed for non-prosecution. Under such circumstances, it is the opinion of this court that the further proceedings cannot be continued, taking into account that the writ petition has already been dismissed. Accordingly, the contempt proceeding stands dropped.
Item 35 to 39.
So, my lord, I have received instructions for all the contempt petitions, and I would like to file an affidavit.
When?
2 weeks may be given.
Okay, Mr. Aibot Thakur submits that he has received the instructions and would be filing the affidavit within 2 weeks. So taking into account the above, list the matter on 12th of December 2025. In the meantime, the affidavit be filed on or before 11th of December.
Public.
3.
Cover case lordship by
Very
lordship.
dismissed. Review no.
Item 41.
Okay. Same na? Where is that? 41 same? Dismissed.
42.
Yes, sir, lordship. Here, my lord asked me to file affidavit regarding justice service notice
But in the meantime, my lord, the earlier incumbent has been transferred.
The order complied with them. Speaking
Order
order has been
complied with.
issued. I'm
You-
having a copy to the other side, and this is a copy there, no? Direction was to consider the representation and to pass an order. Where the copy is given.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. B. Gogoi
Sole
appearing,
respondent.
huh?
Sole respondent.
Appearing on behalf of the sole respondent.
File.
Full stop. The present application has been filed alleging willful and deliberate violation to the order dated 29/1/2025 in WPC number 401/2025, whereby there was a direction issued by the learned coordinate bench of this court by directing the Commissioner and Secretary Government of Assam PWRD to consider the representation dated 6/1/2025 and dispose of the same by passing a speaking order in accordance with law within a period of 2 weeks from the date of receipt of the certified copy of the order. Gustav. The learned, Mr. B. Gogoi, the learned counsel appearing on behalf of the respondent number 1 and 2 submits a place before this court an order dated 1/11/2025, whereby the representations so submitted by the petitioner have been disposed of. Full stop. The said order is kept on record and marked with the letter X, taking into account the above the order dated so-and-so passed in WPC number so-and-so have been duly complied with, for which the contempt proceeding stands dropped. Before parting with the record, this court, however, observes that the dropping of the instant contempt proceedings shall not prejudice or preclude the petitioner to assail the order dated 1/11/2025 in the, if so advised.
I'm 43.
Yes, Mr. Chakraborty. Oh,
During the pendency of this case, my lord, writ appeal was filed and there has been dismissed, my lord. Only with the finding that, my lord, another 60 days time has been given to them to make the payment, my lord. So,
Since that part.
interest is not given.
No, my
But
lord.
it, clarified, it has been interfered with to that extent that if it paid within 60 days, then no interest. Your lordship also said that 45 days, no interest. After that, you have to pay. Division bench has said that another 60 days, if they pay, no interest.
Oh,
So, my lord, only the.
can I modify that
No, my lord.
and give some interest?
No, my lord, the.
When are you to pay?
My lord.
When is the 45 days open, 60 days over?
Have to look at the.
Not necessary.
But, my lord, that will be 30th of December.
30th of December, 60 days? Okay,
No, my lord, it's not like that.
yes.
Lordship will para 29. We, however, modify the impugned judgment, para 29, my lord.
That if the refund of the has not been made up till now, the same shall be done positively within a period of 60 days without incurring any liability to pay interest thereon. So this is of 30/10. Okay, we'll have it on 5th of January.
No, sir. No, let it be after that, I'll not be here.
5th.
After-
Are you not a senior counsel, mister?
My lord,
You,
yes.
you cannot say that. I'm telling you. You don't say senior counsel should not say that I may not be there.
No, my lord,
Mr. Chakraborty can say, not you. When you adorn the ground of
All
a
right,
senior
but-
counsel, you cannot.
I'll be there.
Okay, list the matter on 5th of January 2025 to apprise this court as to whether the payment is directed by this court as to whether the payment is directed by this court dated
Writ appeal 30th, my lord.
No, no.
23/1/2025 in WPC number 66/2024, which was further modified by the order dated 30/10/2025 in writ appeal number 159/2025 have been duly paid.
Only for instruction, my lord, my land friend. Lordship.
44.
As per office note dated 2025, the neither the ID card nor the answer notice has been returned.
What?
Neither ID card nor answer notice has been returned.
Are you interested?
Well,
Huh? Whom?
to the deputy commissioner and the election officer of South Salman.
How will apply Tamser Ali? How is Tamser Ali applicable? Tell me.
No, but
They don't maintain a chronological list.
no, but there is not the Tamser Ali, my lord.
Why you are not being able to serve to the deputy commissioner?
My lord, already we have taken a step by registered court.
Where is this? Is Salmara?
Yes,
Huh?
South Salman.
Service being not complete, list the matter after completion of service.
Much.
This can never happen. You will never get money.
45.
Yes.
In this case, we have
Now
taken
this is-
instruction. First, that budget allocation has been made.
Huh?
It is pending before the finance department
Ah.
for issue financial sanction FS.
Mr. S. Datta, appearing on behalf of the Revenue and Disaster Management Department, has submitted
Also, can I have a look at order this?
that the matter has now been placed before the Finance Department for sanction. Full stop. The said instructions have been placed. An instruction in that regard has been placed, which is kept on record and marked with the letter Y. In that view of the matter, list this matter again on 10th of December 2025 for an update.
47.
Where is Mr. Bingo? Anything done?
My lord, my latest instruction is that, my lord, it is lying with the judicial department. But the
Why?
PDF, my lord, that I already advised them, my lord, this is not necessary since there is a mandamus issued by the honorable court. But, my lord, today, since being a holiday.
Then
my
we issue notice.
lord,
We gave that chance. Because I don't issue it. If I then, the payment found due shall be released jointly and severally by the respondent to the petitioner within the outer limit of from the day. So it has not been done.
Well,
Now, the instant application has been filed alleging willful and deliberate violation to the order dated 8/4/2024 passed in WPC number 1056/2023, whereby this court directed to make verification as to whether the petitioner is entitled to the amount and thereupon to make payment within a period of 3 months from the date of submission of the certified copy of the order before the executive engineer PWD Sipsagar. Full stop. Upon the instant application being filed, this court sought for instructions, thereby requesting Mr. B. Gogoi, the learned Additional Advocate General, Assam, to obtain instruction as to whether the order dated 8/4/2024 in WPC number 1056/2023 have been duly complied with or not. Full stop. This court thereupon took up the matter again on 8/9/2025 and 22/10/2025. Full stop. In fact, on 22/10/2025, it was informed that a demand proposal of an amount of rupees 5.54751 lakhs have been submitted Full stop. Today, when the matter is being taken up, it has been informed that the matter has now been placed before the Judicial Department of the Government of Assam. On inquiry, it was been further apprised to this court that the reason is to seek an opinion as to whether the order passed by this court is required to be complied with or not. It therefore appears that an order passed by this court
This is the
dated 8/4/2024 in WPC number 1056/2023 would now be tested by the respondent authorities as to whether the said order is required to be complied with or not. The same prima facie therefore appears to be in violation to, contrary to the mandate of the Contempt of Court Act 1971, as well as in violation of, and also undermines the majesty of the court. Accordingly, this court issues notice upon the respondent numbers 1 to 5 as to why contempt proceedings should not be drawn against them. The notice is made returnable on 7th of January 2026. The petitioner is directed to take steps by way of speed post. In addition to that, the petitioner is also directed to effect service by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. This court this court appreciates the steps so taken by Mr. B. Gogoi, the learned additional Advocate General, and dispenses with his further appearance.
One more thing, my lord. So far as the respondent number 1 is concerned, my lord, he is not there in the, my lord, PWD.
We'll see. Later on, we'll see. I have issued now contempt.
Yes, they will run now.
Therefore, it is fair. Later, then only things move.
My lord.
Yes, Mr. M. Sakia.
May I please, your lordship. Lordship, on the last occasion, this court made a specific inquiry so as to the terms of Tamshir Ali has been complied with or not. To that effect, lordship, I would like to place this document on record.
Have you verified?
Lordship. Lordship, at serial number 3, serial number as per NITCON 188.
Outstanding so and so. He is on serial number 3.
Lordship.
So, comply with it. Hello? Heard Mr. M. Soikia, the learned counsel, appearing on behalf of the petitioner. Mr. N.R. Sharma, appearing on behalf of the BTC, appears on behalf of the BTC. Good stuff. This court, by an order dated 7/11/2025, had requested Mr. J. Saikia, the learned standing counsel of the BTC, to obtain instruction as to whether the directions passed by this court in the order dated 3/3/2025 in WPC number 7/999/2022 have been duly complied with. Today, Mr. N.R. Sharma, who is also the standing counsel of the BTC, places before this court that due verification has been carried out, and it was found that the petitioner is entitled to an amount of rupees 26,19,218. Further to that, the petitioner's name has also been listed as serial number 3.
No, lordship, 188.
Serial number 188 of the chronological list which is being prepared in terms of Tamser Ali and others versus State of Assam and others reported in 2008 for GLT 1. The said instruction is kept on record and marked with the letter X. So taking into account the above, nothing further remains in the instant contempt proceedings, for which the contempt proceeding stands dropped. The contempt proceeding stands closed. Liberty, however, is given to the petitioner in the circumstance that the petitioner is not paid in terms with Tamser Ali.
Item 50.
Not contempt, Mr. Saikia.
Yes.
What is this? I know affidavit has been issued.
Lordships, we filed the affidavit, Lordships. It's not on record, Lordships. We filed on 7/11 month.
What is this matter about?
Lordships, this application has been filed under section 17B, money.
Oh, yes. Okay.
Our affidavit,
The
Lordships,
affidavit has been filed by the respondent number 1
Lordships.
as submitted by Mr. P.K. Garodia, the learned counsel for the respondent number 1. Taking into account that this is an application under section 17B of the Industrial Disputes Act and requires an urgent disposal, list this matter on 2nd of December at 2 p.m. for disposal of the interlocutory application.
51.
Registry shall bring on record the said. What is this IA? None appears for the applicant.
Correction of all address.
None appears for the applicant on call for the second time. List the matter after 2 weeks.
Supplementary item 64.
The Lordship, service upon the respondent number 6 is still awaited, Lordship.
Who is respondent number 6?
Private respondent, Lordship.
Are you interested with the matter or not? Not interested. Then why you're not serving it by the way, Dusty? Huh?
Dispatched by registered post, Lordship.
What?
It was dispatched by registered post.
You want to take steps by way of Dusty? No.
We'll take.
The counsel appearing on behalf of the petitioner submits that the petitioner would like to take steps upon the respondent number 6 by way of Dusty. So accordingly, list the matter again on 21st of January 2026. In the meantime, the petitioner shall take steps upon the respondent number 6 by way of Dusty routed to the registry of this court and file an affidavit of service on or before the next date.